Your Lordship. Lordship, the wife of the petitioner is suffering from tumor in the uterus, which needs to be get operated at the earliest, Your Lordship. The petitioner is the only bread earner, and he is languishing in custody for no more than 9.5 years. It is running in the list as item number 193, Your Lordship.
Tomorrow at 2. Hand over.
Your Lordship,
Deeply
may I be
obliged, Your
permitted to
Lordship.
mention?
139 and 140 of your Lordship's list. The petitioner is a senior citizen. Lord, 3 days prior to his arrest, he was discharged from the hospital. Lord, again, yesterday he has suffered symptoms of a heart attack. He has been admitted to the CCU of the hospital. In addition thereto, Lord, he has pancreatic cysts and severe liver diseases.
It will be taken care of in the hospital by the jail authorities. No urgency.
Your
Lordship.
Your Lordship.
We appreciate, but we cannot. We are hard pressed. We cannot upgrade matters.
Yes.
No.
There is no injury.
No.
And
No.
this person is
No, we appreciate, but he's already in the CCU. He'll be taken care of in the jail. No. No.
Your
Yes.
Lordship, may I be permitted? With this matter, Your Lordship, this is the Foreigners Act, Your Lordship, the item number 214. This matter, Your Lordship, it was taken up by it's overstay of visa. It was last taken up by the Honorable Justice Joymala Bakshi, Your Lordship, and a bail order was about to be given, Your Lordship, but only a defect on the affidavit. We had to withdraw this matter, Your Lordship. He is in custody more than 580 days, Your Lordship. Your Lordship, the overstay of visa, Your Lordship.
Lordship, may be permitted to mention one matter, Lordship, for application. Lordship, item number 2.
What is the compelling circumstance?
The petitioner's 4 stains have been inserted in the body of the petitioner, Lordship.
No, he's in jail hospital, must be. He must be in jail hospital. No.
Lordship, petitioner has 3 minor child, out of which
Lady or man?
man.
He doesn't have any lady at home.
He has, but
No.
he is the sole breadwinner
No.
of his family.
No. He cannot earn bread even if he gives
His
bail.
younger child is 2 years
No,
old.
sorry, no.
For upgradation, Lordship, in item number 90, the petitioner is sole bread earner, Lordship. He is
He cannot earn bread even if he grant the bail.
custody, Lordship, 7 to 8 months, Lordship.
Sorry, no.
Kindly take up this
No.
matter, Lordship.
Yes.
Up to item number 161. The mother of the petitioner, she has been.
No, not right.
I appreciate one.
Not in every case.
May I?
My lord.
She is such a condition that whether he can see her, his mother.
What is the condition? What is the ailment?
She is in ventilation and severely she is being.
Very well, tomorrow too.
I have given notice to the other.
Tomorrow too, yes.
If your lordship kindly consider.
Tomorrow at 2.
I can feel the fight for application, madam. Only madam, both are 70 years above old man, and only one month madam had operation was done.
No. Yes.
So correction is that is on.
Yes, handle.
May I be
From
permitted?
that side. No, you have already mentioned.
May I be permitted? to-
No. No further mentioning, please. Yes. Mr. Shabuddar, yes.
Next month, madam. And item number 79, day after, not two more day after time is started.
No, tomorrow at 2. This also.
My lord, may I be permitted?
Yes, you.
Both sides.
Mother of the petitioner, my lord, he has been suffering from various different problem of health issue, my lord.
No.
My lord,
No, sorry. Yes.
My lord, the petitioner's father passed away a month ago, my lord. The mother is only at home, my lord. She has been referred to AIMS Patna, and my lord, no one is there to take her there for further treatment.
Hand over tomorrow too.
My lord.
Yes. Tomorrow too. Stop tomorrow too. Yes.
5 of 24, my lord. My lord,
I can't understand you.
my lord, effective 5 of 2024. My lord,
What is the
last
urgency?
occasion- My lord, last occasion, Monday matter was heard, my lord. But it is a legal aid matter. I have filed an application for.
No, sorry. Can't upgrade.
My
My lord, the matter.
No. No upgradation.
My lord, this matter was fixed on Friday, my lord.
Maybe. Yes.
my lord, item
You,
number.
you.
Lordship, in this matter, the petitioner has a 14-month-old child and is the sole bread earning person.
He has his wife at home looking after the baby. No, sorry.
My lord, item number 180 for upgradation in the list. The petitioner is in custody for more than 6 years, my lord.
Lordship, may I permit to mention matter, the petitioner is an advocate in trial court and he is implicated in a false case of 06. So please take the matter.
No.
There is junior advocate in trial court of Alipurduar.
Even then, no. Yes. Yes, Mr. Laxam. List. Yes. Call on the list. Please.
Lordship, we have a request from the bar. Lordship.
Yes, we'll sit till 3:30 for 3 days. Today, tomorrow, and day after tomorrow. Division bench will sit. Mr. Mukherjee, we could have done that if there was consistently continuous 2 PMs, not those were not there. We could have finished half the list last week. We won't do that. On principle, we won't do that. We are trying our level best. We can sit up to 3:30 during court hours in the division bench. But Mr. Mukherjee, no. Call on the list. Yes. Key defect. Jano key defect? Defect. রিপোর্টটা বার করো, রিপোর্ট দেওয়ার কথা ছিল। দাও তাহলে। By an order dated July 26, 2024, the office was directed to give a report which is not there before this court. Full such lapse is not appreciated by the court. Full the office is directed to give a report immediately as per direction dated July 26, 2024 as to whether Vokalatnama has been filed on behalf of the appellant as directed in the said order. Full the matter shall be placed in the list under the heading to be mentioned day after tomorrow, within which time the report should mandatorily be placed with the records. এটা আজকে এখন কমিউনিকেট করে দেবে। নেক্সট সলভ করো। What is the correction?
Instead of Siliguri, it will be Jalpaiguri. Special code NDPS Act, Jalpaiguri.
In the order dated July 24, 2024, the court concerned was mentioned as special court within bracket under NDPS Act, bracket close, Siliguri. So instead of the same instead of Siliguri, the same should be read as Jalpaiguri. Full stop. The order dated July 24, 2024 be deemed to stand corrected accordingly. Next. In the order dated July 25, 2024, the name of the learned advocates, the first name of the learned advocates for the state appeared as Mr. Obhijit Sarkar. So instead of the same the name of Mr. Topon Bhattacharjee be deemed to stand, be deemed to appear in the said order. Next. What is the matter, please?
I am for the applicant, Mala.
Yes.
This is a matter regarding item number 4.
Yes. Item 4.
Yes, Mala. My husband was died, Mala, 19th of April 2014. It's a pension matter, Mala. Family pension, Mala.
Yes.
My husband was died 19/4/2014. Immediately thereafter, Mala, I made application before the competent authority, that is Superintendent of Police, Jalpaiguri. I am being a first wife, my lord, I made application, my lord. And subsequently, my lord, I made several applications, and then you will kindly come to page 44.
What did you want for release of the pension, Mr. Chakraborty?
They are requirement, my lord.
Pardon?
Yes, my lord. Only.
Release of the retirement benefits.
Release of the pension benefit as well as pension.
Very well. Yes. Please continue.
Being a first wife, I am first wife.
Yes, understand. Yes.
Yeah, then Mala requirement.
Page 44.
Page 44, Mala.
Yes.
That is their requirement. You should kindly come to Mala bottom.
So
Mala.
certain documents were asked from you. What is your difficulty in those?
That is not available, Mala, because no objection certificate from second wife. That is not possible for me.
Which are not possible? Just tell us which of the items are given by number.
Yeah, number, Mala.
One is essential. Marriage certificate has to be given.
2.
You have the marriage certificate.
7, Mala. Yes, Mala. Yes.
Pardon?
Marriage certificate not possible, Mala, because it's 60 years long back, Mala.
60.
60
How
years
can you
long
prove
back marriage solemnized.
How can you prove that you are the wife? You have to prove something. Otherwise, how can you be?
Mala, trial court order has been passed by the Mala regarding maintenance, Mala.
What documents out of all these? No. Please stick to page 44, Mr. Chakraborty, for a minute. Which of
Yes,
these
madam.
documents are available to you?
Availability is 3, 4, 5, 6. That is my consideration, do not consider regarding my availability is concerned, madam.
You have 6 relationship certificate means your relationship, that you are the first wife.
Yes, madam. Court
Which
has
is the
ordered, madam.
Pardon?
But they are admitting, madam. You kindly come to madam. They are affidavit, madam, page 46, madam, paragraph 6. I am the first wife, madam, that they are admitting, madam, according to their affidavit, madam, before the trial court, madam. Paragraph 6, madam.
You are Sonekarai. You are
No,
Giribala.
I am, madam, Giribala Bormon, madam, first wife. She is, madam, second wife. They are admitting that I am first wife, madam. But because of their objection, madam, second wife, on the part of objection, account general, they are not getting my pension benefit.
But he
They are
himself did
admitting,
not name
and
you.
subsequently I made reply, madam.
He himself did not, the person, your husband did not name you.
Yes, madam. You also kindly come to page 52 also, madam. Page 52, madam, my reply, madam. Before the trial court,
Yes.
you also kindly come to, madam, middle portion, madam.
Trial court
Last,
means the administrative tribunal. Yes.
yes.
Please
Tribunal.
continue. Yes.
Lastly, file maintenance suit being miscellaneous case number 96 of 99 against her husband in the court of learned STGM Kojbihar. Below the allow the interim maintenance 500 per month and the applicant paying maintenance of 500 from the her husband continuing before his death, that is 27/7/2005. That is passed by the ADGM against myself and my daughter, at the time of death, so that they are admitting their before the trial court, and subsequently, she can't come to pay the necessary arrangement record first wife in her husband's service book to enable him to get her legal hair, provident fund, gratuity, all other benefits husband at the time of retirement, which is on September, October 2005. But after a long time, respondent authorities have not disturbed pension benefit disbursed benefit in favor of the applicant. That following no other argument, petitioner made representation. Before the authority,
Where is the relationship certificate, Mr. Chakraborty? Where is the relationship certificate? You have annexed the relationship certificate.
No, that is not relation certificate. Can be after a long period, my lord. The SGO, the competent authority is refusing to get the certificate because the university kindly come to my special officer, they are Bhavani Bhavan Mala Finance Department, and marriage certificate not possible, my lord. Other, my lord, they are 3, 4, 5, 6. That can be possible at the point of time, my lord.
No, what is the local authority from which you will obtain the certificate? 6?
Local authority means, my lord, it may be Panchayat, SDO or BDO, my lord.
How will they know? There cannot be direct knowledge on that.
SDO and BDO concern, my lord.
Yes, what do you say?
My lord, as per the case.
60 years back, many people don't have marriage certificates.
Yes, my lord. I agree, my lord.
They didn't even know probably
After
marriage certificate was.
After issue of this letter, my lord, at
Yes.
page 44, they directly went to the administrative tribunal. They did not take up the matter with the authority first. Second, my lord, after the passing of the order, my lord, until this order is, my lord, modified, the authorities are hand-tied to pass any benefit to the.
Sir, let us see the order once.
Order is at page 60. This is the last, my lord, 60. I think.
Order second page, ma'am.
This order
So what is your instruction, Mr. Shantanu? What is your instruction? If these are,
first wife, that is admitted. But since the administrative tribunal has,
oh, you admit that she is the first wife.
yes, madam. But the problem is, since this marriage certificate is coming to our way.
3 to 6 she'll give. Marriage certificate will pass an order dispensing with it. Very well. The grievance of the petitioner is limited. First up, the petitioner is the first wife of late Suresh Chandra Roy, comma, who was an employee with the police authorities. First up, the said employee met his demise, met his demise on April 19, 2014. First up, when the petitioner, comma, in the capacity of first wife, comma, approached the authorities for disbursal of pensionary benefit and pension in her favor, comma, the authorities insisted upon certain documents to be produced by the petitioner by a communication dated July 5, 2021, comma, annexed at page 44 of the present petition. Push up next para. Learned counsel for the petitioner submits that since the marriage took place about 60 years back, comma, there was no common practice of obtaining marriage certificates at that juncture, and as such, comma, the petitioner is unable to provide the marriage certificate. Push up, however, comma, the petitioner is agreeable to furnish the documents as enumerated in item numbers 3 to 6 of the said communication, comma, being a detailed report of only daughter of the petitioner, comma, a written declaration made by the petitioner whether any other benefit received from her deceased husband apostrophe's family, comma, a declaration stroke certificate from the competent authority regarding dependent parents of the deceased government employee to ensure they are deemed to be dependent, and a relationship certificate from the local authority. Push up next para. It is contended that it is conducted though. Learned counsel appearing for the respondent authorities contends that in principle, comma, the respondent authorities admit that the petitioner is the first wife of the deceased employee and as such would otherwise be agreeable to disburse pensionary benefits in her favor. Push up, however, comma, the absence of marriage certificate is primarily coming in the way. Push up next para. That apart, comma, the petitioner, comma, without approaching the authorities with such documents as called for, comma, directly went up to the tribunal, and as such, comma, the authorities did not have any opportunity of resolving the issue. Push up next para. We find from the impugned order that there is no infirmity in the same, comma, since the tribunal merely held that the petitioner had challenged only a correspondence advising the petitioner to submit certain documents, and there was no adjudication of rights or adverse order against the interest of the petitioner. For sub next para, we agree with the view of the tribunal that the application was premature. For sub next para, however, comma, keeping in view the plight of the petitioner, comma, instead of further relegating her to the tribunal, comma, it would only be appropriate if specific directions are passed by this court. Push up next para. Since it is admitted that the petitioner is the first wife of the deceased employee, namely late Suresh Chandra Roy, comma, and keeping and taking judicial note of the fact that 6 decades back, comma, there was no prevalent practice to obtain marriage certificates, comma, particularly in areas and communities from which the petitioner hails, HILS, comma, we are of the opinion that the such requirement of production of marriage certificate can be dispensed with. Pushed up next para. Accordingly, comma, WPST 4 of
My lord, one more thing, my lord. Second wife has 2 children. So if the equation is done, that both gets the
no
benefit.
children, even illegitimate children have right.
Yes, my lord.
That is in any event they have a right on in law. Well, we'll make it clear. Pushed up next para. কি বললাম লাস্ট অ্যাকর্ডিংলি এটা কেটে দাও আরেকটা প্যারাগ্রাফ অ্যাড করে দাও at this juncture, comma, learned counsel for the respondent authorities points out that the children of the deceased from the second wife are not to blame, and as such their share in the pensionary benefits need not be taken away. Full stop. Next para. We appreciate such submission and completely agree with the same. Full stop. In any event, comma, even in the eye of law, comma, children of a marriage, comma, even if illegitimate, comma, are fully entitled to the estate of a deceased person. Full stop. Hence, comma, there cannot be any impediment in disbursing the shares of the children of the said deceased employee, comma, even if from an illegitimate marriage, comma, in their favor. Full stop. Accordingly, the pensionary benefits have to be shared between the present petitioner within bracket first wife bracket closed and the children of the deceased employee from the second marriage. Full stop. Next para. In such view of the matter, comma, WPST 4 of 2024 is disposed of by directing the petitioner to furnish the documents as enumerated in the communication as enumerated in item numbers 3, 4, 5 and 6 of the communication by the Superintendent of Police Jalpaiguri dated July 5, 2021, annexed at page 44 of the present application, before the respondent authorities at the earliest, full stop. Upon furnishing such documents, the respondent authorities shall ensure that the share of the petitioner in the pensionary benefits on the demise of her late husband, Suresh Chandra Rai, be disbursed in her favor as well as the earliest, full stop. It is reiterated that nothing in this order shall prevent the disbursing authorities also to disburse the shares of the children of the late employee in their favor as well. No address to cause such a service.
The report.
মানে কাইন্ডলি
প্রথম লাইনে করে দাও, the report filed to be kept
টাইম
on record.
লিমিট টাইমলি প্রেফারেবলি মানে টাইম লিমিট মানে কাইন্ডলি
Well, আরেকটা লাইন তাহলে লাস্টে অ্যাড করে দাও। It is expected that such disbursal shall be made preferably within 1 month from the date of furnishing of such documents by the petitioner. Thank you.
ডিপলি অবলাইজ
Thank you. Thank you for the fair stand. Yes, next one.
ডিপলি অবলাইজ
5, yes.
Lord,
Yes,
as for-
Chaudhary.
Made please, your lordship.
Yes.
Lord, this is an application for bail.
Hmm.
Lord, except section 395 of IPC, my lord, all other sections are magistrate tribal and my lord, less than 7 years imprisonment.
365.
395, my lord.
395, what is that?
Dacoity, my lord. Dacoity.
Record. Yes.
So, my lord,
Hmm.
the petitioners, my lord, they are businessmen. My lord, the crux of the complaint is that, my lord, one Shamiji of Ramakrishna Mission, he lodged this complaint saying that they have a Shevak house in Siliguri, my lord, kind of a rest house in Siliguri, where, my lord, on 19th of May 2024, 10 to 12 persons under the leadership of petitioner number 2 herein, my lord, had vandalized the whatever properties there were, my lord, CCTV was damaged, my lord, the security guards were beaten, assaulted, and my lord, their phones were snatched away. So this was the case.
Such an innocuous offense.
My lord, this was the
You
case.
should be outside. Why were you arrested at all?
My
Mr. Chaudhary.
my lord, allow me to. My lord, out of 12 persons, my lord, 10 persons have already been enlarged on bail. My lord,
We'll recall those orders.
no, my lord, these two petitioners, from the petitioner number 1, there is no recovery. My lord, from the petitioner.
Recovery of what? Arms.
Recovery of stolen
Any article.
articles. Stolen articles. From the petitioner number 2,
You were arrested later, obviously.
yes,
Yeah.
after 7-8 days, I was there. From the petitioner number 2, there is recovery of one broken table fan and one pen drive 8
After 7 days, it may not be recovered from you. Come on, Mr. Chaudhary. You must have disposed it
No,
of.
no, my lord, allow.
And you are indicted in the written the statement of the
Allow
Shamiji.
me to, my lord, substantiate my stand. My lord, what happened beside the Sevak house, there is a property, my lord, which belongs to the petitioner number 2. And due to that, my lord, there was an altercation. That is the only thing, my lord. There was no injury, nothing on any of the security personals. My lord, only the CCTV footages were allegedly damaged. My lord, no recovery from me, nothing from me was taken, my lord. Nothing on me happened. My lord, 10 persons are on bail.
The persons who are on bail must not be on equal footing with 2.
With equal footing, my lord. Equal footing.
2 led.
Yes, they are on similar footing. My lord, on still,
So let us hear them on that at
my lord,
least.
I am 65 days in custody now, my lord. 65, the local businessman, my lord, resident.
Yes, what do you say, Mr. Laksam? The other
It is
10
the
people?
Statement of the 161 statement of Bidan Alvar, who is the co-accused, my lord. My lord, he has implicated Mr. My lord, this accused number Pradeep Roy. My lord, he is the, my lord, leader, my lord.
Co-accused statement is not so valid.
One more statement, page number 200.
No, the complainant, did he give any complaint?
Yes,
Did
my
he
lord.
give any
Yes, my lord.
statement?
That
Show us his statement.
my lord,
He did not know the names, maybe.
my lord, he has named Pradeep Roy in his, my lord, FIR.
The other 10 were also named.
No, my lord. Other name was not named, but Pradeep Roy was specifically named in the FIR itself.
Only Pradeep Roy was
Yes,
named.
Pradeep Roy and other miscreants. That is there, my lord.
How do you distinguish between the other 10 people and him? They all went there and vandalized.
There and vandalized. But upon the instructions of Pradeep Roy,
What is the stage of the investigation?
charge sheet is pending, my lord.
Pending.
Pending.
We'll grant him bail. But we'll strictly say in our order as condition that he will not approach the vicinity of that area, even if he has a business side by or a property. We'll do that. Learned counsel for the petitioner contends that the petitioners were arrested on several allegations, comma, the only cognizable offense being under section 395 of the Indian Penal Code. First up, it is argued that other 10 co-accused persons standing on similar footing as the petitioners have already been enlarged on bail. First up, next para, it is further submitted that the petitioners have a property adjacent to the alleged location of the offense, which belongs to certain religious persons. First up, next para. Moreover, comma, the petitioners are small businessmen and their business and livelihood are being hampered due to the arrest. First up, next para. Learned counsel for the state hands over a statement of a co-accused person which names the petitioner number 2 as the leader of the group which carried out the alleged attack and vandalization. First up, next para. Upon query of court, comma, learned counsel for the state also submits that the complainant specifically named petitioner number 2 as the petitioner number 2 and others. First up, next para. Upon considering the matter thoroughly, comma, we are of the opinion that although the petitioner number 2's involvement might have apparently been active, comma, since he was named as the leader by a co-accused as well as the only person named in the complaint, comma, we are of the opinion that at the end of the day, comma, in view of the nature of the allegations, comma, the other 10 persons who have been granted bail stand on equal footing as the petitioner number 2 as well. First up, in respect of the petitioner number 1, comma, there cannot be any doubt that he is on equal footing as the others. First up, next para. However, comma, we are also not oblivious of the fact that the security of the complainant and the concerned members of the said sect are required to be protected. First up, next para. Accordingly, CRMDB 425 of 2024 is allowed, granting bail to the petitioners on condition that they furnish on condition of furnishing bond of rupees 10,000 to sureties like amount is usual. The next para, that apart, comma, the petitioners shall not make directly or indirectly any ওটা থাকবে. Next হচ্ছে the petitioners shall not, comma, during investigation as well as during trial, comma, approach the vicinity of the location of the alleged offense and or in any manner, comma, approach the complainant as well as the other members of the organization to which the said complainant belongs in any manner. First up, next para. Moreover, comma, the petitioners shall not leave the territorial jurisdiction of the trial court throughout the period of trial and investigation and make themselves available as and when required to cooperate in the investigation. First up, moreover, comma, the petitioners shall also meet the investigating officer once a week during the period of investigation and shall attend each and every date of trial. Full stop. Bas. Thank you.
I'm grateful, Mullah.
Thank you.
For the appellant lordship.
Restoration.
Restoration lordship.
Why were you absent? What is the reason?
I was ill lordship.
You or the client?
Me.
We are allowing Mr. Shahabuddar.
Yes.
In view of sufficient reasons having been made out for the absence of the petitioners on the relevant date, comma, can 1 of 2024 is allowed, thereby restoring MAT 29 of 2024 to its original file and can 2. Sorry, can 2 of 2020. Thank you. Can 2 of 2024 is allowed, comma, thereby restoring MAT 29 of 24 to its original. No, can 1 was also dismissed for default.
Yes, Lordship.
আচ্ছা তাহলে যেটা বললাম thereby restoring mat 29 of 2024 along with can 1 of 2024 to their original files and numbers. Full stop. Let the said matters now be placed in due course before the appropriate bench. Full stop. No orders to cost. Thank you.
Obliged.
Very well. Learned counsel for the appellant submits that the service has not yet been completed. Full stop.
Your
According-
Lordship, please.
Accordingly, let the matter stands adjourned till the next circuit. Next.
Grateful, Lordship.
Same submission is with regard to 7, 8, 9 and 10.
আচ্ছা 8 to 10 বোর্ড একবার দেখিয়ে দাও 8 to 10 বোর্ডে দেখো 8-10 same order in 8 to 10.
Grateful.
Sorry, separate order. একই order copy paste separate. Thank you. None appears at the time of call. Next circuit. Let the matter appear in the next circuit.
11.
You did not respond. What were you doing?
This-
Next matter.
My
Your Lordship, I'm playing for a short passover.
No passover. Either we make it in the next circuit or you start.
Lordship, learned senior counsel is in.
An adjournment is sought by the appellants. Let the matter stand over till the next circuit. Yes.
Look, I should be for the respondent.
But
This is, no, there is no but. There is an appeal preferred from an order of 24th of May 2024 passed by a single judge of this honorable court. Look, the memo has not been served on us.
My leave to appeal is also not getting affirmed today. Milord,
next circuit then.
The only thing is, item number 50 is my appeal challenging the same order. Look, this was a 144 order that was.
Both have
passed.
to be taken up together.
Yes, well, if it could be taken up today, item number 50.
50 Milord,
Did not-
probably Milord, I have.
No,
Milord,
their
50
appeal is defective.
50
They've not filed the appeal. My appeal is filed, albeit with a delay of 28 days. But Milord,
Milord, there also, Milord, probably I have to intervene. Milord, I am representing.
maybe, but the
Milord,
intervention was not allowed. And this by scathing remarks against the police, the 144 order has been set aside. The learned single judge probably missed out on 2 notices that were also assailed. There are 2 notices were assailed and a
But if this
144
appeal is ready, Mr. Banerjee, we are taking up these matters only today. So if it is not taken up, it has to go to the next circuit.
Milord, kindly, Milord, subject to your Lordship's consideration, Milord, both may be, Milord, kept together before the next circuit. In the meantime, I'll serve copies, Mr. Banerjee.
Look, mine will also get pushed back.
Has to. Learned counsel for the.
Could I just, sorry for the interjection. Could I just pray for one thing? Well, the urgency is using that notice despite the writ being allowed. The learned single judge records the writ petition is allowed, just those 2 prayers have not been granted. Because of 11:5, I'm having to pray. I would need
Milord,
an
that
injunction,
order
because I'm
itself,
allowed
Milord,
to.
is under challenge in this appeal, that order itself.
Since copies have not yet been served on the respondent, let the matter stand adjourned till the next circuit. When it will be heard along with. Now, when it will be enlisted along with MAT 67 of 2024 and connected applications. If we can't take it up today, Mr. Banerjee, it has to go to the next circuit, your matter also. Next. No. আচ্ছা আরেকটা লাইন অ্যাড করে দাও আগের অর্ডারটা let copies of the 2 appeals and the connected applications be exchanged in the meantime. So that step will be over then.
Grateful. Excellent.
Great. So this will come up before the next circuit. isn't it?
Next circuit, both the matters together, copies will be exchanged in the meantime. You move your application.
Great.
Yes.
Great.
50 আর কল করো না কি ডিফেক্ট আছে বলো তো None appears for the parties at the time of call. The appellants are directed to cure the defect as pointed out by the office In the meantime, full stop, the matter shall be listed before the appropriate bench in the next circuit. Next. On the way will not do. If you miss the bus, you miss the bus, you can start. An adjournment is sought by the appellant, stroke petitioner. Let the matter stand adjourned till the next circuit. Next. You're for the.
I am for the respondent.
Yes, what is the
I am in
matter?
favor of the applicant, Lordship.
Yes.
The respondent was directed to file one objection.
But now.
Stay application, we have received the copy. We need some instruction because in this, there was a point raised that the qualification obtained.
If you need instruction, we'll give you time. So you want to use a reply to this also?
Lordship.
Affidavit in opposition filed today be kept on record on the period of.
Special bench has already decided this. I have the judgment.
Another non-special bench will decide that special bench has this. On the prayer of the appellant, comma, the time for filing reply is extended for a week from date. Full stop. Let the matter stand adjourned till the next. Next. Thanks.
Lordship, item number 17, I am appearing for the appellants, my lord.
17, you are for the?
Appellants, my lord. I am
Yes,
appearing for the appellants. My lord.
What is the matter,
This is
please?
a matter, my lord, this is a matter of GST matter, my lord. My lord, there was a seizure, my lord, for my appeal is little bit late, my lord. It's there is a delay of 11 days, my lord.
Delay of 11 days. Have you served a notice on the other side? Copy of the.
Yes, my lord, what I have been, I am grateful to, thankful to my learned colleague over there, my lord. It was originally filed before the principal bench, my lord. I have to reserve the notice to the pair, my lord.
No, Ms. Mukherjee, you are now moving the application for condonation of delay or what?
Yes, my lord. Yes, my lord. Initially, my lord, my lord, can one,
What is the affidavit of service?
my lord, that is also with me, my lord. I have already couriered, my lord. My lord, it shows that the original affidavit service could not reach to my learned colleague.
Can. Anyway, the can is not appearing and you have to file an affidavit of service. The connected application is not appearing when the matter is called on today. First of the office is directed to immediately ensure that the application is placed along with the appeal when the matter is next listed. First up, on the next returnable date, comma, the appellant shall furnish a certified copy indicating service of the copy of the connected applications on the respondent. Let the matter be placed before the next circuit. Next.
Grateful, my lord.
Thanks. Next.
18, there is a section 5 application. The copy has not yet been served.
No copy of the section 5, no copy of the condonation of delay application has yet been served on the respondent. Full stop. In order to enable such service, comma, let the matter stand adjourned till the next circuit. Full stop. The appellant shall serve copy of the application in the meantime and file an affidavit of service on the next returnable.
Not even the copy of the memo of appeal has not been served.
Please serve both so that it can be decided by the next bench. If it was served, we could have decided both together probably anyway. Writ matters, writ appeals, how much time does it take? Yes, Mr. Ghosh, what is the matter? Application?
Millard was pleased to take this up earlier, and Millard, the order passed by the Millard Honorable Single Judge was stayed by your Lordship. Subsequent to which, Millard, your Lordship had directed the state authorities, Millard, to file an affidavit to the stay application. That has not yet been filed till date. Millard, my respectful submission, Millard, this can be disposed of the appeal because the entire writ petition, Millard, to some extent has become infractuous.
If they agree to the disposal of the appeal, we can. Thank you. What is the appeal about, Mr.?
Yes, Millard kindly takes, Millard, the impugned order. Millard, in the writ petition, Millard, the subject matter of challenge was a section 94 notice under the CRPC.
Which order is under challenge? 24th of August or the previous order?
Millard, 23rd of August.
23rd of August.
Yes.
24th August is not under challenge.
24th August, Millard, I'm sorry.
24th August.
24th August.
Yes.
Very yes. What is the matter? Please take your seats. I'll call upon you. Yes.
Yes, Milord, the subject matter of challenge before the Honorable Single Judge was a Section 94 notice. Milord, we submitted before the Honorable Single Judge that in a pending investigation in a case under the POCSO Act, the notice requiring documents from the school authorities should have been directed to the secretary, not the president. Because the president, according to the managing committee rules, is not the custodian of documents. This was our point of challenge. Now, Milord, the Honorable Single Judge, Milord, expanded the scope of the writ petition and went ahead to dissolve the committee.
Yes.
Went ahead, Milord, to dissolve the managing committee. And Milord imposed cost of Milord a lakh of rupees. Milord, being aggrieved by only these two things, Milord, we preferred this appeal.
Where is the order?
Yes. Milord, internal page 2 of the order dated 24th August. Milord, the last.
What was the nature of the allegation made in the complaint?
Milord, in the POCSO case, Milord, the
POCSO
yes.
against the headmaster.
Yes, the accused person was the headmaster.
Probably that is why these findings are.
Yes, yes.
There might be justification in these findings, sir, because sometimes you go overboard, but that overboard, you take advantage of that. But findings, I mean, we don't know.
No, Milord,
So furnish those documents.
that has already been done. In fact, Milord, in this appeal, Milord, the Honorable Division Bench, Milord, while hearing this appeal on the last occasion, asked us to file an
Exactly,
affidavit.
that is what should be enclosing those
affidavit
documents.
disclosing whether you have complied with that. Milord, that affidavit is on record. That's before your lordship. We have
So
said
you are agreed with the dissolution of the
dissolution
committee.
of the managing
Show
committee.
us that
Milord,
portion of the.
internal page 2, the last line. However, it appears that there is a deep conspiracy to stall the proceeding against the said headmaster.
So if we set it aside, that dissolution, that you will be satisfied. That is
Yes,
only.
that's all. That is the scope of my
Yes,
appeal.
what do you say? I dissolved.
No, your lordship.
I have stayed that order.
Dissolution.
I'll make that absolute. Will dissolve. No. Regarding the furnishing of the documents, you are absolutely right. They have already. That is the only scope of the appeal and the application. How can we dissolve? Learned counsel for the parties agreed to the appeal itself being taken up with the application for disposal. Push up next para. Please take your seat, sir. Please take your seat. The scope of the appeal is extremely limited. Push up. Next para. The writ petition was filed challenging a notice under section 94 of the criminal procedure.
That's right. 91, I'm sorry.
And it's under section 91, thank you. Under section 91 of the Code of Criminal Procedure. First up, the context of the case was that there were allegations against the headmaster of a particular school under the POCSO Act. First up, in connection therewith, the investigating agency wrote a letter, apparently to the president of the managing committee, seeking certain documents in aid of the investigation. Full stop. The petitioner's challenge was that the secretary and not the president was the custodian of the documents and ought to have been addressed in such notice. Full stop. Next para. While hearing such challenge, the learned trial judge vide impugned order dated August 24, 2023, read a deep conspiracy to protect the headmaster into the action of the managing committee and went ahead to dissolve the managing committee itself. Next para. Upon query of court, it is submitted by learned counsel for the appellant that pursuant to a direction of court, in the meantime, an affidavit has been filed disclosing that all the documents which were sought by the investigating agency have in the meantime been furnished. Next para. Learned counsel appearing for the respondents do not disagree to the said statement regarding all documents having been furnished. Next para. Upon hearing learned counsel for the parties, we find that the impugned order, particularly with regard to the dissolution of the managing committee of the school, is palpably dehors the jurisdiction of the court and entirely beyond the purview of the subject matter of the challenge in the writ petition itself. Full stop. Moreover, the findings against the managing committee were premature and would only be the subject matter of an investigation. Full stop. Next para. Accordingly, MAT 148 of 2023 along with CAN 1 of 2023 are allowed, thereby setting aside the impugned order dated August 24, 2023, passed in WP number 1929 of 2023, and restoring the managing committee. Full stop. Next, full stop. Next para. It is, however, made clear that this court has not expressed any opinion on the merits of the investigation and or the subject matter of the same, and it will be open to the concerned investigating agency as well as the trial court, if the matter reaches trial, to come to their own findings independently, irrespective of any of the observations made above. No address to cost.
The earlier order, 23rd August, a cost of conduct was imposed upon this. Can you text about
Cost by division bench. We have set aside the impugned order. Oh, the earlier order. Full stop. Consequentially, the order dated August 23, 2023, passed in WP 1929 of 2023, imposing costs on the writ petitioner is also set aside. Thank you. Thank you so much. Yes. Yes.
Matter is here, Advocate Sri Bhattacharya is appearing, is reading the matter, and he is not available now. He is in Parliament.
Lord, item 20, I beg to appear for the appellants, my lord. Mr. Bikashan Bhattacharya is appearing in this matter.
On the prayer of the appellant, let the matter stand adjourned till the next circuit. Next.
Grateful.
Please give the names both. Yes. Yes. This is that annual matter comes up before once a year. This is not that. Not related to election in any manner. Name of the part. What is that? What is the application about?
The voluntary teachers, they are praying for the regularize of the service lordship. But in this case, in filing, there is a delay of some days lordship. 76 in one matter.
Filing the appeal.
Yes, lordship. And
So this is that condonation application.
the respondent appeared last date and day 6 time for filing opposition against the delay lordship.
So yes, Mr. Pal, I'm sorry. Yes, where is your? What is the reason given? Hey, application ta bar kore debe sob shomoy. Eta? Yes, it's great. 75 has been scored through in our copy and 77 has been written. Let us see the reason given. Internal red tapeism. We should condone the delay. Have you filed your opposition? Very well. Learned counsel, heard learned counsel for the parties, full stop. We are of the opinion that internal red-tapeism, TAPISM, was the reason for the delay, full stop. Being sufficiently convinced of the sufficiency of the reasons, CAN 1 of 2023 is allowed, thereby condoning the delay in preferring MAT 172 of 2023, full stop. The appeal be registered duly. Full stop. Thank you. Let it be called on just, yes. Similar delay. Expression must be same. Maybe copy paste also. Maybe copy paste also. Yes, 77. So same order. So thank you. Wait, what? REB hyphen 23 similar also.
175 days delay. 175 days delay, lordship.
Reason, cause is the same.
Yes, doctor.
We have not mentioned the dates, that's why. When number of days we have not mentioned so that we can copy paste. So same order in all that. Up to which item? Up to 26 similar? You are appearing in all the matters for 24th. Have you served copy? Miss Singh, have you served copy? You are appearing. Then we'll pass similar order. You are appearing up to 26. Achha, so 24 similar order also? 24 is similar order. Please give the item numbers and the names. So otherwise it will be confusing. 25 missing. Is there any other side? You have served on the other side?
I have all matter I have made service.
Mr. Bormon, you are appearing for the state. Mat 179 of 20. You are Mr. Bormon, Hirok Bormon. Mat 179 of 2023. Your name was recorded in the previous occasion. We'll regularize your appointment. We'll say that you are in court. Mr. Hirok Bormon, comma, learned advocate who appeared for the state on the last occasion when the matter was taken up, comma, is present in court today. Full stop, let his appearance for the respondent for today in the present matter be regularized by the appellant authorities, by the state. Full stop. Next para. Tarpar বাকিটা এক। Rest is the same. 26 call karo formally. If it is similar, then same. Same. Thank you. These are unnecessarily pending for Scola because we cannot reach due to the bail matters. We can understand because 500 or that has to have precedence, but this has to be touched by somebody. Yes. Please repeat, Mr. Pal.
State the appellant before.
Yes.
The delay has already been gone down, led by additional advocate general in this matter.
Is not
The
there.
application needs to be filed, whether that has not yet been.
Oh. So we'll just adjourn it till the next circuit on your prayer and we'll record the reason. Learned counsel for the appellant submits that an application for stay is required to be filed and seeks some time to file the same. Full stop. Accordingly, let the matter stand adjourned till the next circuit to enable the applicant to file such application. Yes, Mr.
I beg to appeal for the respondent, Jalpaiguri Jalpaiguri Development.
Mr. Banerjee, Mr. Pal is there. Mr. Nobankur Pal, he has asked for time for filing stay.
Appeals are ready for hearing, I believe.
A separate appeal is prepared by you also, Mr. Banerjee.
I'm led by Mr. Basu. The same order challenged by both the
Please
parties.
exchange copies, Mr. Shah, in the meantime. Mr. Shah, Mr. Banerjee, Mr. Basu, exchange copies in the meantime and come back in the next second.
If you not see, can you take about Thursday or Friday any suits?
No question, sir. No. Particularly since you are appearing.
No, it's so harsh.
Very harsh. The bail matters are more harsh on the litigants. Yes, next matter.
Then it will not be taken up any day, my lord. Whenever he
No. Sir. Whenever I come next in the circuit, they wait till then.
Oh, very good.
Next matter. Call on the next.
I am raised for the respondent in the item number 27 and 28 and appellant in item number 29.
Please give your names accordingly. So all the matters same order at a 30. Now we have called 30. Yes, please. 30.
Lordship, I am for the appellant. On the
On your prayer, last circuit it was adjourned. That's recorded at least. Mr. Dhod was there. Yes, what is your matter? What is the application? Two applications for what?
two applications, one for stay
The other?
and other both the petitions were not heard and directly
What is the other application about?
condonation.
What is the delay? What is the delay?
That has condonation.
Condonation for filing the appeal or condonation for delay in filing the appeal?
Yes, condonation has already condoned.
Achha, allowed?
Now,
No. 1 minute. Let us check that. Not allowed.
Directed applications were not taken up, my lord. But the matter was heard, my lord. State was directed to file an affidavit, my lord. State has done that.
To the condemnation application also.
No, no, not in the condemnation application, but in the memo.
Condemnation, what is the delay? You are not ready in your matter. You are not ready in your matter. You don't even know whether the condemnation was allowed or not, and you're moving the appeal. Not done. You get an opportunity to move the writ petitions, writ appeals. You're not taking it. You should have been prepared in the matter.
Just
You don't even know the number of days of delay. I can bet that they are more sure of the number of days of delay than you. বসে আছি কন্ডেমনেশন অ্যালাউ করবো বলুন Pardon? Can do. What is the number of days? Please tell us. Please move the application for them. What is the reason for delay and what is the number of days? Thank you very much.
beloved
Acha.
wife.
Oh. And
It
not been mentioned.
on 16,
What is the number of days? Number of days of delay.
number of days, 1 month plus.
Yes, we are allowing it. The can 2 of 2023 first. In view of sufficiency of the delay, sufficiency of the reasons for the delay having been explained before the court, comma, can 2 of 2023 is allowed, thereby condoning the delay in preferring MAT 185 of 2023. First of, let the appeal stand registered. First of, no rise to cost. Yes, what is the matter about?
Matter is the impugned order challenged by the appellant is that medical negligence, loss of want of infrastructure, and thereafter inquiry, and that on inquiry stopped, and the petition under section 226 is also not within the jurisdiction of the learned honorable single judge.
Why?
Inquiry under West Bengal clinical
Establishments.
establishment, inquiry has to be conducted by the CMOH, and a committee is already formed, and thereafter an inquiry was made. And if the petitioner is at all aggrieved by that order, then he ought to challenge under section 26 of the Clinical Establishment Act for appeal. But they have not preferred any appeal. They have directly come up with a petition under 226.
Please show us the provision of appeal. An inquiry report was filed by that committee.
Yes.
Is it appealable?
No, due to
When it was committee was submitted, so it was 3-member committee who submitted this report to the case.
Right.
After receipt of the report, it was as per the clinical establishment, the report has to be placed before the district magistrate for taking a period. That was one.
So, what did you pray in the writ petition?
in
You are for the?
State.
Oh, achha, well,
Lord, in the writ
what was your stand in?
My lord, the present writ petition was filed before the single bench because in the ground that the hospital establishment was a prohibition order under section 21 of the Act, my lord, was passed. And the prohibition order in terms of subsection 5 of section 21 that has to be seized after 6 months of period. Now, my lord, after 8 months, we approached the Honorable Writ Court for cessation of such prohibition order. Now, my lord, the Honorable Single Judge was pleased to pass an order in favor of the writ petition. Now, my lord, they have challenged that order. Lord, kindly takes up, my lord, section 21, subsection 5, my lord.
But that is not reflected in the order. In the
Lord, that
order,
is not reflected in the
the order says something else.
My lord,
Inquiry
only a
committee shall
complaint
be,
has been made, an allegation was made, and for that reason, my lord.
the inquiry committee has to stand dissolved as per this.
Yes, my lord. After 3 months, if they
That
wouldn't
is-
have submitted the report after 3 months, now, my lord, the section 22 is very clear regarding.
Lordship.
No, first, to 22.
My lord, kindly takes up section 22, my lord.
Yes.
No, it's a regulation. My lord,
Oh, sorry.
inspection of,
Explain this one. No, 22 of the West Bengal Clinical Establishment 2017 Act.
Yes.
22 is something else. He has to that officer has to furnish a report within 7 days.
My lord, now they did not do that. Subsequently, my lord, there is a time bound period which says that, my lord, kindly takes up section 21, subsection 5, my lord. Kindly takes up 21, subsection 5, my lord. A prohibitory order shall cease to have effect upon the licensing authority being satisfied on an application made by the clinical establishment not less than 6 months after the prohibition order has been passed, that the clinical establishment has taken sufficient measure justifying the lifting of
So it's not automatic. That satisfaction has to be there then.
Yes, my lord.
Then
Now,
it's not automatic.
my lord. Now, my lord, this order was the writ petitioner approached the honorable writ court after his
8 months.
natural justices were violated. My lord, I tell your lordship the story in crux, my lord. On 12th of December 2022, one unfortunate incident happens where the wife of the of the appellant demised. Well, subsequently, a complaint was lodged before the CMOH Chief Medical
See,
Officer.
what was to be done, we are not on this story, but you may have been guilty, you may not have been guilty.
My lord.
But licensing authority is to issue a certificate under 6.
My lord.
So we can direct the license, subject to hearing them. We can direct the licensing authority to, have you made that application after?
My lord, I have done that. My lord, kindly take.
We can direct that to be decided by the licensing authority within a limited period.
That has been done, my lord, already. A report has been submitted.
No, licensing authority has said that report, no, under subsection 6, please come to subsection 6.
Yes, my lord.
CMOH, yes. So that report was under subsection 6 of section 21.
Yes, my lord, they have done that.
Inquiry committee was constituted by the CMOH himself.
And you have said that sufficient measures have been taken by them.
Measures were taken by
Our license has been renewed. In 2023, our license has been renewed. 2024 as well, our license has been renewed.
So where is the scope? Your writ petition was infructuous when the order was
My
filed.
lord, the writ petition was filed on 8th of August 2023.
No, when you moved the writ petition, that was infructuous.
My lord, I tell your lordship, my lord, maybe there are clouds. My lord, I tell your lordship what has happened, my lord. Kindly grants me 30 seconds. On 12th of December 2022, this demise happened, my lord. My lord, subsequently on 19th of December, on 20th of December, and on 21st of December 2022, prohibition orders were issued against the establishment, my lord. Subsequently, my lord, after such prohibition order was issued, my lord, the establishment made several representation. One notice before the director and other doctors of the establishment were served to let them come before the inquiring authority. They appeared before the inquiring authority. They cooperated with the inquiry. After doing everything,
That
they have
6
made
months expired. 6 months expired.
6 months expired in the month of June.
June, 19th, 20th June.
My lord.
After that, what happened?
Subsequently, my lord, 9 representations were made before the Chief Medical Officer of Health, Darjeeling. Now, my lord, subsequently, 2 more representation before the Special Secretary.
That representation was in the nature of an application under subsection 5, 21(5).
Yes, my lord. Yes, my lord. Even though in the application, my lord, that was particularly not mentioned. My lord, I fairly submit, my lord. I tell your lordship why. Because, my lord, till that time, the copy of the complaint even was not supplied upon the petitioner.
Subsequently got the complaint.
My lord, we got the complaint during the hearing of this appeal, my lord. Not even in the writ court, my lord. During the hearing, kindly seize the order of this appeal, my lord. In the third last order, my lord.
No, say then what was the subject matter of your challenge? What did you ask for in the writ petition?
Lord,
that the prohibition be lifted.
Yes, my lord. Because
but that could not have been done before you file proper application. You could have asked for the copy of the report to be
now if that is the case, my lord, our principle, the rights under natural justice was violated. My lord, I beg your lordship.
We agree. Suppose even if you agree, then your relief would have been to ask for a copy of that report against you, the initial report.
My lord, they have submitted in the
Or the
read code
complaint.
that the report has not been yet submitted. That's why the read code again gave 3 months time to the CMOH.
That was not the report under 6 then. That was the initial report.
No, my lord. No, my lord, kindly see the date of the
complaint.
report. Kindly see the date of the report. The appellant have submitted.
See, you have not, till date, you have not made any application under 5. You had made representations, but you have to make a proper application saying that safety measures have been taken. During pendency of the appeal, you have got a copy of what? Which report?
Which was finally submitted by the committee.
No, that report was the premise of the initial prohibition against you.
No, no,
Was
no,
it?
Not, my lord.
It's a subsequent thing.
Subsequent inquiry report. The inquiry was done against us, and that report was placed.
So that inquiry report was after the 6 months,
Yes,
after
my
the
lord,
lapse.
yes.
Incident happened.
Show the report then.
No, just tell us.
Takes up my affidavit, report in the form of an affidavit.
Yes,
Madam takes up the second para of the state affidavit.
yes. Second para.
Madam, I'm reading from the mid portion of the state paragraph. Madam,
Yes, yes. This was contemporary. You are right.
yes, the report was submitted on 13/12/2000.
This was the basis of the initial prohibition against
That
them.
was the complaint by which started.
Inquiry of the 3-member committee which was formed by the CMOH himself.
And on the basis of that, the initial prohibition was
On
granted.
the basis of
Yes.
that prohibition was made.
Made.
Put upon the clinical establishment not to.
So this is the initial report. According to you also, no application under 21(5) has yet been filed. But they say that they have received a copy later.
My lord, can you see my affidavit in opposition? My lord, page number.
You can file only a reply.
My lord,
Opposition, they will file.
I have filed.
Oh, opposition to this report.
Yes, yes, my lord, in of
Right,
this,
right.
appeal, my lord.
Exception to the.
Exception, my lord. Kindly see page number
Where is that exception?
113, my lord, of the opposition, my lord.
Huh?
My lord, a detailed representation was caused before
It-
the CMOH and other authorities, my lord.
No, it is read.
My lord, the read petition has been annexed. I'm reading from
So
that.
just tell us this. This report, now you have got this report in this affidavit in the form of a report or report
Yes.
in the form of an
Yes.
affidavit, the initial report, which castigated you for the prohibition order to take effect. Now you have got a copy of this. Now you only have to make an application. We can give you that liberty within a week, file an application under 21(5), indicating that we have taken these safety measures and they'll take a step on that under section 21(6). That will resolve your issue.
That I have, my lord, I bow down to your lordship. But my lord, the thing is, the act itself does not give any scope for prohibiting our establishment because my lord, there are 17, 18 workers left.
No, the difficulty we are
The
telling.
establishment is shut, my lord.
We are telling you, it's not clear. 21(5) says a prohibition order shall cease to have effect upon the licensing authority being satisfied on an application made by the clinical establishment not less than 6 months after the prohibition order.
That we have done.
So the prohibition does not automatically get lifted after 6 months. Rather, your limitation for filing an application which you have already crossed.
My lord, I have filed that application. I have filed that. My lord,
Oh, you have filed that application, but you are no.
but no
Even if
complaint
you
was made to us.
Even if you did not file that application, we will be lenient on that because you will record that you have got a copy of the report during pendency of the appeal. We'll extend that time. Therefore,
I have no problem doing that. my
the
lord, but-
prohibition is not automatically lifted, contrary to
that-
what
that
you
is not
submitted.
automatically lifted.
No, it
That-
will never be lifted
Yes,
if you
sir.
don't file that application.
Yes. I have to file that application only upon the satisfaction it can be lifted.
Right.
I agree, my
So
lord.
do that now. You have got a copy of the report.
My lord, that is not the issue of the appellant, my lord. Kindly.
We'll try to convince the appellant.
Yes, my lord.
The inquiry committee itself was dissolved.
My lord,
That cannot be lifted. He's right. We'll set aside that order.
my lord, I tell you.
We have to set aside that order. We'll give you liberty to file separate.
Kindly appreciates my point, my lord. After expiry of 8 months of that order, of that prohibition order, my lord, we approached the writ court because we did not have the copy of the complaint which was filed before the CMOH. We did
Writ
not
court
have.
order is bad by we are telling you.
Well-
Writ court order could not have been passed because of the reason that without an application under 21(5) and satisfaction being recorded under 21(6), as all of you only pointed out to us, it cannot be done. It could not have been lifted.
Understand, my lord. I
Beyond
bow
its
down to your
jurisdiction.
lordship. I bow down to your lordship. Does not matter.
Run a bit further, let us decide
Well,
the
kindly hears me, my lord. It will be affecting the whole establishment. All the 20 doctors along with the worker, they will.
The workers, don't speak about them. You are only concerned with your institution and your profits. Workers, nobody thinks of the workers, nobody thinks of the workers. We give lectures and sermons in our orders. People in the political sphere also give that. Advocates may be somewhat sympathetic with the workers, but let the workers have their say now. We'll give you liberty within a fortnight, file that application. Within a month after that, they'll decide and they'll take steps.
But till that time, our establishment will be shut, my lord.
Yes,
My lord, kindly
yes.
consider,
No,
my
no.
lord.
If you have not
We
complied,
nothing to do with the date. My lord, kindly seize. A consent form was signed by them, my lord. They have.
See, these infertility clinics, these have become a corrupt business
My
now.
lord, this infertility clinic.
we do not know.
First infertility clinic in Siliguri, the director of this infertility clinic.
Just
sent to
because of your
opinion of this idea with Subhash Chakraborty. She was in the team of the Subhash Chakraborty.
Maybe, but we don't know whether after that corrupt practices, because often it happens, the founder member is the last person who is listened to. We are telling you in these, not only this, several clinical establishments, founder members open with lot of aspirations, they are cast out of the window and other people take over. We don't know that.
That is not.
We are not- we are-
calls for a report from the state. They will.
We will not call for anything. If we call for another report, your workers will starve for another month. And the next circuit will not be able to take up. The circuit after that will not be able to take up because of the bills.
Lord,
We are disposing it off.
Kindly, my lord, do not stay the.
We set aside, not stay. Set aside the order.
Do not close the establishment, my lord. I beseech your lordship because there is nothing left in
This
it.
order is palpably bad.
Even in compliance with the order, they have filed a case in consumer court as well, my lord. They have followed. They have complied with the order. Now, my lord, they are asking for set aside of this order, my lord. Kindly cease.
Complaints were under compulsion.
Yes, my lord. I understand, my lord. Kindly do not shut the establishment, my lord.
No. It was shut. It was opened illegally.
After 6 months of prohibition, my lord, after 8 months of prohibition, my lord, we have.
It will be prohibited forever unless you file an application, sir. You have not filed an
That, my
application.
lord, kindly takes up 113 of the opposition, my lord. We have done that.
No.
We have done that, my lord. Several representations were caused. My lord, kindly seize. In total, 9 representations were caused, where we have said that we have taken all the measures. We had absolutely had no fault. My lord, kindly let me point out, your lordship, because we have stated, we have made.
In the writ petition, did you challenge the original prohibition order also?
Yes, my lord. Yes, my lord. It is reflected in the impugned order, my lord.
See, you may have a justification that learned single judge said that before the inquiry is done, it could not have been stopped. Now the inquiry has been done.
And the report is not against us, my lord.
Report is already on record.
There is not against us, my lord. Nowhere it is said that.
What is your report? What do you say in the report? Was there any reason for shutting it up?
Lapses from the part of the matter takes up page number 10 of my page. Or it comes to the last paragraph.
Yes.
The significant findings which also came to the notice of the members of the committee. There was no GNM staff posted at the center. Designated RMO was not appointed. There was no record of post-operative examination of chest in case of major surgery. There was also no record of examination of abdomen.
Are these still there? You have
Yes, my lord. No,
rectified.
my lord. They were not even there when the report was filed. Kindly seize the report. It is undated. Kindly seize the report, my lord. It is undated.
I have explained that. Why it is undated. I have explained it in my.
What did you say? Why it is?
The report is, it doesn't have any date, but
And my lord, every measure has been taken.
Submission of the report is already there.
There's a covering letter.
Yes. This is the inquiry was caused, the date of order 12th of December 2022, and thereafter the inquiry was conducted on 2 successive dates.
When did the prohibition take effect?
19th of December 2020.
There was a prohibition. Subsequently, the single bench lifted the protest stay on the.
No, but this report is subsequent to that.
Yes.
So at that point of time, when the writ petition was filed, there was no report.
Yes, but on the very next day, the.
No.
See, this is the only report we have, right? So this report indicates from the covering letter that this was not there when the prohibition took place. Therefore, why shouldn't the prohibition be lifted and liberty be given to you rather to conduct an appropriate inquiry? But we can also consider this. Now, then you have to issue a fresh prohibition on the basis of this. But the initial prohibition was without any inquiry report, so that has to go. Yes, what do you say?
I refer 97 of the page 97, the initial inquiry was done.
You are for the, you are, who are you?
I am for the appellant.
Please don't say I'm for the appellant. Who is the appellant? What is his interest in that? What is your?
Wife of the.
You are the initial complainant.
Yes.
97, section 97
No, page 97.
of the writ.
No, of written objection. Opposition.
না ওটা করবো ওটা
The inquiry was conducted.
অরিত্র কিচ্ছু আলাদা করে দেওয়া নেই, অপোজিশন ইফে একটু করে দাও। ঠিক আছে, বার করেছি। পেজ 97 সব গাঁথা হয়ে
Yes.
গেছে। Yes, 97.
Annexure P6.
Got it. What is there?
This is the inquiry. Inquiry conducted on 22/2020. It's within time. And the shortfall has been clearly narrated. Now our submission,
Yes.
number one, the petitioner could approach before the appellate authority under 26. That has not been done. And under 25, no petition has been submitted. If is 26, appeal to the appellate authority if the petitioner.
Absolute, it is not an absolute bar to 26. Appeal is not an absolute bar if it's palpably dehors the jurisdiction or palpably illegality. But you say this report was there by the same way.
Yes.
Not a patent perversity.
Yes. And thereafter, the report was referred, so far as I find from the affidavit of the state, it would reveal on 6/6/2023, report was addressed to the district magistrate for conducting adjudication under section 35 of the Clinical Establishment Act. It's chapter 5. And chapter 4 is the violation. Report itself is very clear that there is violation. Now,
You appeared on the before the learned single judge.
learned single judge, but the my learned friend who appeared before the learned single judge could not place the.
No, was the affidavit in opposition filed at that point of time when the impugned order was passed? No. This is the final disposal of the writ petition. After that, how could you file affidavit? The affidavit in opposition has been filed here.
Yeah. Affidavit in opposition here by the respondent number.
You have discussed, but that inquiry report was there. Yes.
The report, my lord. My lord, it says that Shastro Shati registration was not done. My lord, we are not more than of beds, more than 30 beds.
So you are given 7 days. Where is your answer to this?
Yes, my lord. Kindly sees. Lord, kindly sees page number 98, my lord.
But after that, after 98, inquiry committee was constituted.
Yes. Then we appeared, my lord. There
Let
is
us
a
see that.
compliance to that as well, my lord. 30th of January 2023, my lord. We have appeared. Now, my lord, considering all these things, in 2023, our license was again renewed. if, my lord, we had any discrepancies, our license could not have been renewed. Now, my lord, subsequently,
Well, after the prohibition, unless the prohibition was lifted, how could it be renewed?
my lord, the prohibition was lifted by the order of the writ court, my lord. And at
No,
that,
no, order of the writ court is under challenge here. We are looking into the veracity of that only.
my lord.
Suppose you are before the writ
My lord,
court.
the license, the application for license is on a different stage. My lord, we have made that under section 5. And they
When the
consider
writ
they
court,
have
when the writ court passed the order, the writ court apparently took this into consideration. That inquiry was initiated in 2022 and it held that even till August 2023, there was no there was no culmination of that inquiry. But in spite of that, you had been prohibited.
Yes, my lord. Yes, my lord.
Can you show us anything that apart from this, there was any other inquiry report at that point of time? We don't find it.
No, my lord.
What do you say to this? You had made a complaint. You have placed before us this page 97. 97 is a chance given to them to answer certain queries. But there was no inquiry as such.
Inquiry,
It has to be preceded by an inquiry before taking the serious step of prohibiting. So why?
then I like to refer
Yes.
for your lordship. On the basis of this inquiry, they have submitted the report. And
Where is that report?
thereafter, that report which has been referred.
Now it has been given much after the writ petition during pendency of the appeal.
Is,
At the relevant point of time when the prohibition took place, there was no inquiry at all. And the learned single judge is then correct.
Because inquiry was conducted, my lord, it might-
Much after.
The report.
Yes.
Inquiry was conducted.
Much after.
The report as it specified, it was conducted on 20th of December 2022 and 28th of December 2020.
And prior to that, on 19th.
Prior to that, on 19th, the prohibition order was issued.
Even before the inquiry, my lord, the prohibition order was passed against us.
Will not set aside this, but will direct a fresh inquiry to be done by them.
As your lordship.
I will do that. On the basis of your complaint, they'll undertake a fresh inquiry and look into it whether any violation is there. We'll put it time bound. I will ask you what will be a reasonable time. And after that, this process will be reinitiated. Till then, this order should not be interfered with.
Lordship, I have one more.
What is that? Quickly. We cannot wait indefinitely.
Page 111.
What is that? Tell us. Don't keep the suspense.
Submission of death report and all details.
How does it help you?
They have
There are two components of the complaint. One is a baby died.
mother died.
The mother of the child died. So why that complaint should have been taken up separately, because this is a different inquiry altogether. Regarding the death, whether there is any negligence, was there any inquiry on that? Because all this inquiry is apparently whether they have a license, whether they have this, that. Regarding your complaint, what was your complaint? That they were negligent in the death.
They were negligent on the for the death of the wife of the.
But that speaks of that. That requires a different inquiry as to whether there was any negligence, and this is on a different footing. See, listen to us. Listen to us. There are two types of inquiries. One, whether they have complied with the norms. Two, whether even if they complied with the norms, they were negligent for this particular death. We will direct them to the clinical establishment. The authorities can initiate a fresh inquiry regarding your complaint regarding individual negligence for your wife, as well as whether the norms are violated by them. Two inquiries can go on ahead. Yes, what do you say for the state? Because there are two types of inquiries. One is regarding whether they have complied with the norms. Even if they have, then also regarding his individual complaint regarding the demise, whether there was any negligence, you also have to look into that. So we'll direct to inquiry to both. Right. No, we won't. We will not interfere with the impediment. Yes. The scope of the present challenge is with regard to the order of the learned single judge, whereby the learned single judge directed the learned single judge set aside an order of prohibition of functioning of the writ petitioner, which is a clinical establishment, comma, by lifting such prohibition, full stop. Next para, the present appellant was the complainant at whose behest an inquiry was supposedly done before such prohibition was imposed. Full stop. Learned counsel for the appellant argues that there was an inquiry preceding the prohibition, and as such, comma, the impugned order of the learned single judge is bad in law. Full stop. Learned counsel places reliance on Annexure P6 at page 97 of the establishment apostrophe S affidavit in opposition filed in connection with the present appeal, which, according to learned counsel for the appellant, comma, was the said inquiry report. Full stop. Next para. Secondly, comma, it is argued that section 26 of the West Bengal Clinical Establishments within bracket registration, comma, regulation and transparency bracket closed act, comma, 2017 provides for an appeal against an order of prohibition, full stop. Hence, comma, the writ petition itself was not maintainable before the learned single judge. Full stop. Next para. While answering the issues, comma, learned counsel appearing for the clinical establishment submits that the prohibition was done without any prior inquiry, and as such, comma, the order of the learned single judge was justified. Full stop. It is further contended that the livelihood of several employees of the hospital are dependent on the outcome of the present appeal, and as such, comma, the appeal court may not interfere with the impugned order. Full stop. Next para. Learned counsel for the state places reliance on the report filed in the form of an affidavit before this court to indicate that there was an inquiry and the report thereof has been placed before this court. Full stop. Yes. Not feeling well? Immediately go, have yourself checked. You can go with him also. Somebody can be sent with. Ki bollam? Full stop. Next para. It is thus contended that in the absence of any application under section 21 within bracket 5 of the 2017 Act, comma, there could not have been any occasion to lift the prohibition. Full stop. Next para. Upon hearing learned counsel, comma, we find from the materials on record that although a report was actually filed, comma, the same was authored after the order of prohibition. Full stop. Next para. Annexure P6 at page 97 of the affidavit in opposition of the establishment filed in connection with the appeal cannot be said to have been a report. Full stop. It is evident therefrom that the same was merely a query from the clinical establishment by the CMOH, comma, Darjeeling, as to whether certain steps had been complied with by the clinical establishment. Full stop. Next para. Thus, comma, there was substance in the impugned order inasmuch as the prohibition was not preceded by any proper inquiry. Full stop. Next para. Insofar as the bar under section 26 is concerned, comma, we are of the opinion that the hands of the writ court are not tied, comma, by an alternative remedy, comma, in the event it is found that there was some palpable illegality and or gross miscarriage of justice. Full stop. Next para. We are also aware of the well settled position of law that
Lordship, I may be
that the appellate court, comma, in an intra-court appeal, comma, is extremely cautious so that its own views are not substituted for that of the learned single judge, and unless there is a palpable or patent error of law and fact, comma, there is generally no interference in intra-court appeals. Full stop. Next para. Thus, comma, we do not find from the materials on record that there was any palpable illegality in the impugned order of the learned single judge, whereby the prohibition was directed to be lifted. Full stop. Next para. However, comma, at the same time, comma, we are also of the view that since the present appellant had taken out a specific complaint on the demise of your wife,
Yes.
on the demise of his wife, comma, all aspects of such complaint ought to have been inquired into by the respondent authorities. Full stop. Para, there are two components of such complaint. Full stop. First, comma, that whether there was any negligence on the part of the clinical establishment concerned in the sad demise of the wife of the appellant. Full stop. Secondly, comma, whether the clinical establishment concerned has duly complied with all legal and procedural norms in its functioning. Full stop. Next para. Since the authorities were initially of the view that there were certain infirmities in the functioning of the hospital for which initially a set of queries was made, comma, we are also of the opinion that a fresh inquiry should be held by the respondent authorities on both the counts as indicated above. Full stop. Next para. Accordingly,
Lordship, one line. The complaint was lodged before the police station. On the basis of that, the inquiry was held. Now, if the fresh inquiry on two counts, the appellant may kindly be allowed to file a fresh petition to the CMOH
for what?
for the purpose of conducting the inquiry.
We are going behind that. We are giving you more. We are saying a fresh inquiry has to be held by them from the inception. There, all of you will get opportunities. I will make that clear in an order. You'll understand, is not opposed to that in principle. Accordingly, MAT 185 of 2023, along with CAN 1 of 2024 and CAN 2 of 2024, are disposed of without interfering with the impugned order, but with the observations given herein below, :1, the CMOH, Darjeeling shall initiate and conduct a fresh inquiry into the allegation as to the concerned clinical establishment within bracket respondent number 1 herein bracket closed not functioning in accordance with legal and procedural norms. Full stop. Secondly, and number 2, the other inquiry has to be done by the CMOH also. Number 2, the CMOH shall also inquire as to whether, comma, irrespective of compliance or non-compliance of the above norms, comma, there was any negligence on the part of the respondent number 1 clinical establishment in the demise of the wife of the present appellant. Number 3, in connection with both the above inquiries, comma, the CMOH shall give appropriate opportunity of hearing both to the clinical establishment as well as to the appellant stroke complainant and or any other party who might be interested in the outcome of the said inquiries. Full stop. 4, it is expected that both such inquiries shall be completed within outer limit of 2 months. Within outer limit of 3 months from this date. Full stop. Next, the paragraph point at after conclusion of such inquiries, comma, the CMOH shall take appropriate steps in accordance with law in pursuance of the outcome of such inquiries. Full stop. The written outcome of the inquiries shall also be communicated by the CMOH both to the complainant as well as the clinical establishment concerned immediately after coming to its conclusion. Very well. For the above purpose, comma, the CMOH will be at liberty to form a fresh inquiry committee and take all due steps in accordance with law afresh without being influenced by the outcomes of the previous inquiry and or the previous procedure undertaken by him.
Grateful, Lordship.
Item number 15. One of the bridge connecting Siliguri to Jalpaiguri near Southline.
What happened in 15? What did I do? What did you do?
next circuit, so please, at any time, I'm ready. It can be.
We have made it next circuit. Always we give an opportunity to the learned junior no, we always give an opportunity to start the matter. If the matter was started, we would have heard you. No.
He got stuck up there.
Not your fault at all, but also not the court's fault and not the fault of the other persons who have matters after you. We'll take those matters only. Sorry. Come up in the next circuit and move the matter.
No.
We'll come back in 5 minutes for the next matter. I'm sorry. Up to 3:30 today. So we were thinking that we'll take these matters up to 3. And from 3 to 3:30, we'll take up some bail matters. Because otherwise bail, the prisoners are languishing in behind the bar. So we'll take up from 3 to 3:30, we'll be taking up these matters. Let us carry on with this up to 3.
Can we circulate this?
Please do, please do. We are formally telling it from 3 to 3:30, we'll be taking up bail matters. Colin.
Well, I'm for the appellant in this matter.
Yes.
For the private respondent, your lordship. Private.
There's a delay of 26 days in filing of the appeal.
Application is there.
Yes, can one.
Your lordship, this matter belongs to Mr. Counsel Ravi Shankar Chattopadhyay. We
Cannot belong to him.
he's leading this matter, your lordship. We could not serve a copy of the petition to him. So I'm taking an adjournment.
You are there. If you are against you, then we will give time. Let us allow the
Limitation maybe.
limitation. Will immediately allow. What is the reason given?
Well, departmental approvals.
In view of being satisfied, with the sufficiency of the cause shown for the delay, can 1 of 2023 is allowed, thereby condoning the delay in
Can 1 of 2024.
Can 1 of 2023 allowed, thereby condoning the delay in preferring MAT 186 of 2023. First of, let the said appeal be registered. So what is the contents of the appeal?
Well, this is against a order to reinstate an Anganwadi worker.
Do you have a good case or a medium case or a bad case?
I believe I have a good case.
Then let Mr. Chattopadhyay come. It will be taken up in the next second. Let the appeal in view of the because if you are in their favor, then I would have heard her and যেটা বললাম তারপরে in view of the adjournment sought at this juncture on behalf of the private respondent, let the appeal stand adjourned till the next second.
I am for the PT.
My lord, I appear for the private respondent numbers 4 and 5. My lord, I'm led by Mr.
My lord,
Shah. He's appearing.
My lord,
on.
I appear for the respondent numbers 4 and 5. My lord, my colleague Mr. Shamriddha Sen has worked very hard. My lord, kindly permit him to argue the matter. I'm there.
Thank
but
you.
kindly
Thank you.
permit.
Thank you very much for that. Thank you so much. Yes, Mr. Roy.
Yes.
You have a formidable opponent. Because he's a junior, he's much junior to you, so he's formidable in our court.
No.
Now you have to be extra cautious since Mr. Shaka has.
I've seen you the first day in the Court of Justice, Niran Mitti. That day, I was with just a matter who appeared. Do you remember? Rule number 2.
Yes,
So
yes.
that I remember. So there are no question junior and seniors.
No, there is a question. They get an advantage. It's unequally balanced against
I have
you.
a very bad matter. Even I did do. What happened, my lord?
Mr. Rai, yes.
There are 26 days of delay, my lord. And on merits is that
26 days delay will condone and then hear the appeal.
on merit is that
Very well. What is the reason for the delay?
22 days.
What is the reason?
This is my lord. Failed. An advocate has not filed it. Nice.
In view of sufficiency of the reasons in the delay being occasioned in preferring the memo of appeal, can 1 of 2020 is allowed, thereby condoning the delay in filing the appeal. And full stop. Let MAT 199 of 2023 be registered. The next line, the appeal is now taken up for hearing. Yes.
My lord, the petitioner was a non-teaching staff called as a secretary post in a laboratory schools. She was terminated without following the departmental proceedings. She filed this petition before this Honorable High Court.
Non-teaching.
Secretary was a non-teaching staff, not teaching staff.
Oh, secretary. Yes.
Secretary.
Yes. Then
And laboratory school is a ICC affiliated school. It is admitted.
it is maintainable.
That I'm coming. That I argue that I lost him. I'm also in doubt. I can't say. So
satisfy you ask on that also. Yes.
Laboratory school is an ICC school. On this one, it was dismissed.
Yes.
So I challenge the termination order. The Honorable Single Judge dismissed the writ on the ground that it's a private school. It does not lie. But that I at page 52, this is all input order.
So that is the reason, only reason for it.
Yes.
Yes. Satisfy your ask.
Yes, only on the ground, the article doesn't count Article 12, so it does not lie. Now I'll satisfy your lordship.
Not an absolute bar, but it has to be on high ground.
My lord, if you are a teacher, then I have a public function. I'm not teacher, so I say I have come to in another manner. What happened, my lord?
There is no public law element here.
No, I'm not.
If there was a public law element, yes, if
And
it affected education at large, then we could understand.
No, yours is correct. This is Supreme Court views that if a teacher, just exhibition judgment that discharge a public function, so it lies. I'm not going, but I'm a secretary, I'm not a teacher. But I show the one judgment. Before that, I just place the fact of the case. The school is the ICC schools, is affiliated to the ICC.
Now CISC
No,
board.
it's ICC. ICC.
There's a C, yes.
So, my lord,
I know, I passed through.
these schools are, my lord, under the governed by the regulation of the Anglo-Indian and listed. This is what this regulation is at page 16. You will also kindly come to page 16.
Yes.
My lord, this regulation may be called the Code of Regulation for Anglo-Indian and other listed schools. So I got it, madam. Page 16. You will also kindly come to, this is framed by the state government under the executive instructions. Now you also kindly come to page 17, the definition of listed schools. Listed school means an English medium school which does not come under the particular the definition of the Anglo-Indian schools, but is recognized under this code for the purpose of presenting candidates for the council board examination under such terms and conditions as the state board and the Department of Education made possible, provided that such to fulfill the council conditions laid down such and such. So, my lord, this school admitted listed school. It is framed under this regulation. The statutory force is there. You also kindly come to page regulation. This is, my lord, page 20.
Yes.
Paragraph 20, clause 24 is the procedure for disciplinary action against confirmed staff. It has been given.
Yes.
So, my lord, my submission is that, although, my lord, I'm sorry, so those are not in the writ court before the single bench. I really said, but my submission is that this laboratory school is an ICC school, a CSC school, is governed by this regulation, and this regulation framed for the benefits of the teaching and non-teaching of the schools, and that this procedure of this has been framed therein. They have dismissed me from the service without following the discipline given here. So I have challenged it. My submission is that it is under the violation of statutory regulation. Now I just want, I'll show only one judgment. 2023, 4 SSC, 498. Your Lordship, 75-4. 75-4.
Yes.
I just place it.
Last page.
Last page, my lord.
Yes.
Even if it is perceived that imparting education by the private school is a public duty within the expanded expression of the term, an employee of a non-teaching staff engaged by the school for the purpose of administration or internal management is only an agency created by it. It is immaterial whether A or B is employed by the school or to discharge that duty. In any case, the term of employment, the contract between school and the non-teaching staff should not be constituted an inseparable part of obligation to impart education. This is particularly in respect to the disciplinary proceedings that may be initiated against a particular employee. It's only where the removal of subordinate teaching staff is regulated by some statutory provisions. Its violation by the employer is in contravention of law may be interfered by this. Even it's a public function, my lord, apart from public function. My point is that, my lord,
What was the question which fell for consideration? Let us see that.
determination.
Writ maintainability, was it under?
Here, my lord, there's a, yes, here's a.
Yes, 2.1, para
Yes,
2.1.
here's a non-teaching staff of his, he was terminated, that was already brought to the Supreme Court, decided on various points, even my lord, that's.
But
teacher-
here it was held that no element of public law is.
Yes, I'm not going to that. I'm going to use statute regulations. My lord, now I have, this is separable that my lord is a teacher, he has said, discharging duties, public element is there, but I'm moving on, my lord.
There is a public element of law undoubtedly in the discharge of duties, in the nature of duties. True. If those duties were not discharged, if a student came up, we could have still understood. But this dispute is not regarding discharge of public duty.
I'm not going to that.
This is between you and your employer.
I'm not going to discharge duties. I'm not going to that.
Breach of law, breach of law.
I'm going to the breach of statute provisions. But it is held in my High Court.
Mr. Rai, in intra-court appeal, just because another view is possible, we do not take that. You know that, you have taught us that also. So, Mr. Rai, no interference. If we were the writ court or Justice Bishas was the writ court, we could have understood. Before the appellate court, very limited. No.
I know my limitation, so I say this.
Learned counsel for the, we have heard you. Learned counsel for the, heard learned counsel for the parties. First up, the limited question is whether the learned single judge was justified in rejecting the writ petition only on the ground that the respondent school therein is not a public entity within the contemplation of state under Article 12 of the Constitution of India is justified in law. First up, next para. Learned counsel for the appellant places reliance on the definition of listed school under the Code of Regulations for Anglo-Indian and other listed schools, 1993. Pushed up in the said code, in clause 5 within bracket 10, within double inverted listed school has been defined to mean an English medium school which does not come under the purview of the definition of Anglo-Indian school, but is recognized under the code for the purpose of presenting candidates for the council/board examination under such terms and conditions as the state board and the Department of Education may prescribe, provided that the school fulfills the conditions as stipulated therein. Push-up learned counsel also relies on clause 24 of the said code, which lays down the procedure for disciplinary action against confirmed staff. First up, the writ petitioner / present appellant was a secretary and a non-teaching staff of the school. First up, the grievance of the writ petitioner is that without complying with the provisions of the code as laid down therein, the writ petitioner was terminated from service. First up, next para. Learned counsel thus argues that there was a statutory infraction, of such a serious nature which called for interference by the writ court. First up, next para. Learned counsel places reliance on St. Mary's, namta dekhe likhe niye, reported at 2023 4 SCC 498, where the Supreme Court, inter alia, while answering the issue as to whether a writ petition was maintainable and whether in service matters there could be interference, held that even if it is perceived that imparting education by private unaided school is a public duty within the expanded expression of the term, an employee of a non-teaching staff engaged by the school for the purpose of its administration or internal management is only an agency created by it. First up, next para. It was also recorded by the Supreme Court that in any case, the terms of employment of contract between a school and non-teaching staff cannot and should not be construed to be an inseparable part of the obligation to impart education. First up, this is particularly in respect to the disciplinary proceedings that may be initiated against a particular employee. First up, however, the Supreme Court further held that it is only where the removal of an employee of non-teaching staff is regulated by some statutory provisions, comma, its violation by the employer in contravention of law may be interfered with by the court, full stop, but such interference will be on the ground of breach of law and not on the basis of interference in discharge of public duty. Full stop. Next para. It is thus argued that the said criteria having been met, MET, in the present case, comma, the writ court ought to have interfered under Article 226 of the Constitution. Full stop. Next para. Learned counsel for the respondents controverts such submission and argues that no element of public law is involved, and as such, the learned trial judge was justified in passing the impugned order. Full stop. Next para. Upon careful consideration of the ratio laid down in St. Mary's Supra, comma, we are of the opinion that the same did not deviate from the well-settled proposition that interference may be made by writ courts even in cases involving private entities, comma, provided a public law element is there in the impugned action. Full stop. As held by the Supreme Court in the cited judgment itself, comma, the terms of employment of contract between a school and non-teaching staff cannot and should not be construed to be an inseparable part of the obligation to impart education, comma, which could have a public law element. Full stop. This is particularly true in respect of the disciplinary proceedings that may be initiated against a particular employee. Full stop. Next para. Although the Supreme Court provided a short window for interference by the writ court in case of breach of law, comma, in the case referred to by the appellant herself, comma, the Supreme Court refused to interfere, comma, holding that it is apparent that no element of any public law is agitated or otherwise made out. Full stop. Next para. Applying the framework of the said judgment to the present case, comma, the infraction complained of by the writ petitioner stroke appellant is purely within the domain of the service contract between the petitioner stroke appellant and the respondent school. Full stop. As such, comma, there was no element of public law involved. Full stop. We do not find any such palpable illegality or gross miscarriage of justice which would, comma, at the first blush, comma, prompt the writ court to interfere, comma, deeming it to be a gross statutory violation or a violation of fundamental right having a public law element. Full stop. Next para. We would be failing in our duty to mention that even in cases where there is a breach of law, comma, there either has to be an infraction of a statutory provision or fundamental right, and or an inaction on the part of a statutory authority on the count of its legal duties imposed by law, which has to be palpable and there has to be a public law element, comma, which is the underlying common refrain in interference under Article 226 of the Constitution. Full stop. Next para. We do not find any such public law element in the present case. Full stop. Next para. That apart, comma, it is well settled that the appellate court is doubly, DOUBLY, cautious in interfering in intra-court appeals, and there cannot be any interference merely because on the same set of facts, comma, a different view would be permissible. Full stop. Even if we were to have the opinion that in the present case, comma, there could have been interference by the writ court, comma, we choose to refrain from interfering with the order, comma, since the view of the learned trial judge was one of the plausible views available to the said judge. Full stop. In such view of the matter, comma, we do not find any scope of interference. Accordingly, MAT 199 of 2023, along with CAN 1 of 2023, are dismissed without any orders to cost. Full stop. However, comma, it is made clear that nothing in the above order or the order of the learned single judge shall preclude the petitioner stroke appellant, comma, if otherwise permissible in law, comma, to invoke the appropriate remedy for the grievances ventilated before this court.
Your Lordship, now the writ lies in the Bar Association.
Pardon?
This is one writ in the schedule, the writ petition lies against the Bar Association. It's settled by the High Supreme Court.
In respect of Bar Association?
Yes.
Discharge of public function, yes.
Yes.
It also lies against the public school. We have also held that in a private school, but under the considerations.
No, no.
As we told you, if a student came up and said that
That is,
public duty is not being discharged,
Somebody has come to me and said, read against the Bar Association. The junior from here, he has shown me the judgment. Say,
whose judgment?
the Supreme Court says yes. It lies against the Bar Association because this is a public function.
There are judgments of the Calcutta High Court also.
Yes, by quoting the
Yes.
dismiss. My lord. Yes.
Next. Thank you.
Grateful, Lord.
Thank you. Yes.
I'm appealing for respondent of 5 and 6.
Yes, Mr. Singhani, respondent.
5 and 6, Your Lord.
I'm for the appeal, Lordship. Lordship, I kindly liberty grant me, Lordship, to file the supplementary affidavit, Lordship.
Supplementary affidavit to what?
Lordship, I did not annex the writ petition copy and orders. Yes.
You have copies, those copies hand over, we'll take those on
Yes,
record.
I have.
If you have certified, no. If you have those copies, the writ petition and writ petition must have been available with them also. What is your ground in the appeal? What is the can?
Can is the can for stay, Lordship. Stay.
So have you given copies of these supplementary to them?
Lordship,
Then let us come back in the next circuit. We'll permit you to file those.
Lordship.
Leave is granted to the appellant to file supplementary affidavits annexing relevant documents. Full stop. Such affidavits filed in court to be kept on record. Full stop. Copies thereof are handed over to the learned counsel for the respondents here and now. So let the appeal be listed along with the connected application before the next circuit.
Good.
Thank you.
Lordship, I am for the appellant, Lordship.
Yes.
Item number 34 is similar to item number 21 to 26. Lordship, in this matter, there is a delay of 295 days, Lordship.
21 to 21
26, Lordship.
21 to 26 একটু অর্ডারগুলো দেখে নিও যে নিয়েছে একদম কপি পেস্ট হবে সেম অর্ডার
Grateful, Lordship.
No, the other side is not happy. Oh yeah,
Yes.
right. So same order.
Lordship, I am for the
Yes, please. What is the matter?
Lordship, in earlier occasion, the respondent authority were supposed to file affidavit.
They have not filed. We'll give them a last chance. We'll record that in our order. If they don't file within a week, then it will proceed without that.
Yes, Lordship.
Learned counsel for the appellant, comma, in her usual fairness, comma, points out that although directions were given to the respondents to file their affidavits in opposition, comma, none has been filed as yet. Full stop. Next para. As a last chance to the respondents to file their affidavits in opposition, comma, the time for filing such affidavit is extended. We'll extend it for a fortnight. For a
Yes,
fortnight from date, full stop. The time for filing reply is extended for a week thereafter, full stop. In the event no affidavit in opposition is used within the said extended period, comma, the hearing of the application shall proceed without such affidavit. Full stop. Let the matter be placed before the next circuit for hearing.
Grateful.
But please communicate, ma'am, please communicate this order to your other side so that they can. If you don't file it within a fortnight, then it goes. Without affidavit, it will be hard. We have said that in order. কিন্তু ওনার নামটা রেকর্ড হবে না because we have already recorded none appearing. Post facto no. Otherwise, the entire order will have to be recast. Sorry. Next.
Well, I am for 36, my lord.
I am on behalf of the state.
State. Yes. You are for the appellant.
My lord, for the petitioner, my lord, I am for the petitioner, my lord.
Yes. What is the matter? What is the application?
What is the GST matter, my lord?
So we should release on personal ground.
Well, I am for the petitioner, my lord.
All right. But what is the application? Application for stay?
No, my lord, the penalty has been paid, my lord. I have challenged the seizure order, my lord. So cause notice against the seizure, my lord.
No, there's a
But if the
can
matter
one.
can
What
be
is the
kept
can one for? Sir, what is the can one for?
But
my lord, day after
Say.
tomorrow I'll be appearing physically, my lord, but let the matter be appearing on Thursday, my lord.
Sorry, sir, but difficulties, we are taking up different matters because this is a limited circuit. So day after tomorrow, we have fixed other matters for being taken up. So it has to then go to the next circuit.
My lord, then,
Learned
the next circuit, my lord.
Learned counsel for the appellant seeks to appear personally in order to assist the court properly. Full stop. Let the matter stand adjourned till the next circuit.
Grateful, lordship.
Thank you. Yes. GST সারাদিন লেগে যায় বুঝতে Respondent.
Item number 37.
None appears for the appellant, although the respondent is represented. Let the matter stand adjourned till the next circuit. You are not suffering an interim order. Not today. And the next circuit. Not today, মানে next circuit. কিছু লিখতে হবে না। Order pass করবো? আচ্ছা। খালি not today করুন। এত order লিখতে করতে গেলে অনেক টাইম লাগে স্যার। Same. Not.
I am for the appellant, Lordship.
39?
Yes, Lordship.
39 you already?
Yes, Lordship.
তা 39 টা not to করুন দাও। Where is the other side? What is the application for?
Stay.
Can to stay application.
Condonation application, this
Already, it has
that has been allowed. Give a notice to the other side. What can?
We have given notice they are.
What is the appeal against? In the absence of
So
the
that-
respondent, you are
Your
appealing.
lordship, I appear for the appellants, your lordship. I was praying that this matter could be taken up in the next circuit bench. We were required to
number,
file
sir?
a supplementary affidavit.
You look at
40 কে হবে।
কত নম্বর এটা?
40.
39.
She's probably.
This is 39. Miss Pandey.
Your lordship, 38. It's on the board, it's showing 38, your lordship.
Board, our computer has hung.
Your lordship.
So
My
board,
apologies.
board zeal for the persons whose bail petitions are pending. Anyway, so
They have already.
what is the challenge about?
Challenge, there was a tender matter.
What matter? What matter?
Tender.
Tender.
Tender matter, the respondent was successful, L1 bidder. Subsequently, the opening of the financial bid, he has written a letter that since it appeared that it was not suitable for his purpose, he has written a letter for withdrawal from the process. That is not permissible under the NIT.
This requires a hearing. Give a notice to the respondent. We'll record something in our order that you are present, they are not. So that on the next occasion, even in their absence.
But we are paying for stay because already they have.
Oh, acha. Then satisfy us prima facie.
Content.
Let us see the impugned order once.
It's annexed to.
Yes.
Although we have filed our instruction, it was also not looked into and no opportunity was given to file affidavit for bringing all these papers.
What has been done by this order?
We have been asked to refund the earnest money and remove the blacklist. As per the
Show us the provision whereby they cannot withdraw because one of their partners was suffering from cancer.
Yes, but they are still continuing with the work. We have also.
Where is the provision? Please show us that. The provision in your tender clause. Tender document.
At page 72 of the stay application.
23.
Clause 23.
The appellants have made out a prima facie case for hearing of the appeal on merits, inasmuch as, in terms of clause 3 of the tender document.
23.
Sorry, the first portion is.
Page 72.
Yes, but the first portion has been cut off in the merging. That's why you can. Clause 23.
Clause.
as in terms of clause 23 of the tender document, comma, withdrawal of e-tender, comma, once the bid has been submitted online and after passing of end date for submission and has been accepted for further proceeding, comma, is not allowed, comma, whereas the learned single judge permitted such withdrawal to take place even after the said cut-off date. Full stop. Accordingly, let the matter be heard on merits. Full stop. There shall be an interim order of stay of operation of the impugned order till August 31, till September 30, 2024, or until further order, comma, whichever is earlier, full stop. The respondent shall file their affidavit in opposition to the application within 3 weeks from date, full stop. Reply, if any, shall be filed within a week thereafter, full stop. Liberty to the parties to mention for enlistment after the above timeline is completed. Give a notice to them so that they can comply. Otherwise, they will miss their opposition. Again, it will. Yes. Nothing doing.
My lord, I appear for the appellant, your lordship.
Yes, nothing doing. 40 who is appearing?
My lord, item for 40, I appear for the appellant.
Yes. What is the matter?
My lord, the matter is that, my lord, the impugned order passed by the learned single bench, my lord, was passed ex parte. And my lord, I was not provided with an opportunity of, my lord, filing any affidavit. The matter pertains to, my lord, a tender which was called, I am the Mal municipality, your lordship. A
Yes.
tender was called by me for construction of wall from one particular house to the other, and the total bid value was 33 lakhs and odd.
Right.
Now, my lord, within there was a certain time period of 6 months for completion of the work order. What happened, my lord, is that the writ petitioner claims to have completed the work order, but at the time of, my lord, inquiry, it was revealed that the brick wall that he has constructed had already fallen down within the completion period. And my lord, an inquiry was made by the municipality upon a mass protest by the, my lord, local, my lord, villagers, upon which, my lord, the inquiry report, my lord, is there with us in the, my lord, office, from where we can establish, my lord, that, my lord, the wall, the inquiry sees to see, my lord, that the wall, work has not been completed properly. And my lord, I was not even given an opportunity to place all these through an affidavit before the learned trial court.
What was done by the trial? You are the contractor.
No, I am the municipality.
Oh, municipalities.
Yes.
No, but
it was
the
my
learned
tender.
single, Mr. Mondal, the learned trial judge holds that the chairman, on account of paucity of funds, requested the petitioner to reduce the amount.
Yes, my lord, there was an inquiry.
Of these can 2, my lord.
Yes.
It is their document and something new has been placed before the revision.
No, your lordship, if kindly comes to the last para of that document, it reveals that there was an inquiry which was started, but the inquiry report was not filed till that date.
Which paragraph? Which page?
My lord, page 80, as relied on by my learned friend.
Last
the
paragraph
last
of
paragraph.
that? Yes.
Prior to that, my lord, yes, on a prima facie, my lord, inquiry or a prima facie verification, it was found that the brick wall was constructed. That is why we have admitted that you have worked for an amount of 25 lakhs and odd out of 33 lakhs. But thereafter, my lord, kindly see, after preparation of bill at our level, a mass petition from the locality where the work was done has been received by the Mal municipality office. Accordingly, the sub-assistant engineer Mal municipality was instructed to make an inquiry in the matter and submit a report in this contract. But unfortunately, due to engagement in other financial, the inquiry was not done by the sub-assistant engineer. My lord, I am told, I have been instructed that this inquiry is complete, and my lord, the report is lying in the office of the Mal municipality. So, my lord, that opportunity I missed to place this report before the learned trial judge.
I'm not. This is in the second round of writ petition. This order was passed, my lord, which is the impugned.
Initially, Justice Sarkar had directed the hearing to be given an order.
Yes, and according to the directions of Justice Sarkar, my lord, this my lord, resolution
No, but the
was
inquiry
passed.
was pending, Mr. Pal.
Kindly sees what they are saying.
That was one of the grounds also. There are two grounds in this letter. One is that inquiry is going on. The second is that presently financial condition of the Mal
Yes.
municipality. That was not the sole ground.
If you also can see the second last paragraph, page 81.
Yes.
In this position, considering the opinion and financial position of the of Mr. Shopon Bhumik and also the
Oh.
financial condition of the Mal municipality, the chairman requested Mr. Shopon Bhumik to reduce the amount of bill to rupees 17 lakhs so that the payment may be made smoothly in 3 equal installments to be started from July 23rd. Malad.
This is, if this comes to the entire amount claimed by you.
No, yes, they have
No,
reduced it.
Mr.
Malad.
Pal, there are two components. They are asking for a reduction. If you agreed to the reduced amount, they would have paid that. But still, they took the point of inquiry also. Now, therefore, there were two components. If you agreed to the reduction, then there is an admission on their part. But the admission cannot be, this is not an unqualified admission. Admission only if you agree to the reduced sum, then they are willing to pay. But not that your entire sum is payable. Now, therefore, the admission is not unqualified regarding your entire claim.
They are saying that due to
No, they-
positive fund,
No,
they
no,
are
not,
willing
no,
to
no,
pay,
no.
you reduce it.
Not only
This
that.
is the one interpretation, Malad.
Acha.
No, not at all.
Let us just once see.
Yes, Malad.
But the last two paragraphs of page 80 are very telltale. Clearly disclose that inquiry is going on. And then, however,
No, my lord, that was agreed to as per the, my lord, order of Justice Shorkar at that point of time.
Yes.
But my lord, it was also stated that because the sub-assistant engineer on prima facie verification had accepted that 25 lakhs work was done. But
but
thereafter,
Mr.
when my lord-
Mr. Mondal, you
yes,
referred to
yes.
the inquiry, but that was not cited as a ground for non-payment. You ultimately agreed to the entire dues.
No, my lord, that is what I am
Because
saying,
the
my lord.
subsequent paragraph says, after you referred to the inquiry, right?
Yes, ma'am.
In the last paragraph of page 80, please come from there.
Yes.
That inquiry and the matter remains pending since long.
My
After
lord.
that, in next page, you say, however qualifies the previous portion. Presently, as per order such and such, source of fund.
Yes.
So you agreed to the entire amount and you said that you will pay them.
My lord, that was
Why
done.
should the appellate court interfere, Mr. Mondal?
My
Two
lord,
views
kindly,
are possible.
kindly, my lord, grant us an opportunity to place that affidavit, at
No,
least before your
no.
lordship, if not before the
No,
trial
after
court.
your admission, Mr. Mondal, I could have directed the writ court to give you that opportunity. We could have given you that opportunity, but provided you had not given this admission.
My lord,
This
but
is one
at
of the
at-
plausible views.
No, absolutely. Your lordship is absolutely. My lord, I bow down to your lordship under any circumstance. But my lord, the inquiry as on date is an admitted position. And my lord,
No.
till that time when the resolution was passed, the inquiry report was not there available with us. Which we, and thereafter, my lord, when the matter again subsequently came before the learned trial judge, my
No,
lord,
after
we were
having
not present.
after this admission, Mr. Mondal, you cannot rely on that inquiry anymore. That
My lord,
was a plausible view taken by the court.
kindly grant us an opportunity to place that inquiry report
No,
before your
no,
lordship,
no,
and then
no,
your
Mr.
lordship
Mondal, sorry.
considers.
No,
Kindly
no
grant me,
interference.
my lord, kindly
No.
grant me 2 days time at least, my lord, to
No.
place that report. That
Learned
is
counsel
pending, my
for
lord.
the appellant argues that the learned trial judge,
And my lord, only one more thing, my lord, one more thing, my lord, apart from this, my lord, very important, my lord, the tender was issued to the partnership firm. Whereas, my lord, the writ petition was filed by one of the partner in his individual capacity and not as a partner of the firm. So now, my lord, even if I, for the sake of argument, my lord, if I say that the payment is due, it cannot be paid to the partner in his individual name. It has to be, my lord, paid, my lord, to the partnership firm. The writ
learned
petition.
counsel for the appellant challenges the impugned order on twofold grounds. First, it is submitted that the writ petitioner stroke private respondent had completed certain work for the appellant municipality. However, and there was an ongoing inquiry into certain deficiencies in the work of the writ petitioner. Next para, without considering the same and also without taking into account that no opportunity was given to the appellant municipality to file an affidavit in opposition to the writ petition, the writ court disposed of the writ petition by placing reliance on a purported admission by the municipality that the amount in question was due to the writ petitioner. Secondly, learned counsel for the appellant argues that the writ petitioner could not, in his personal capacity, claim dues of the partnership firm, which was the entity which did the work in question. Push up next para, learned counsel for the respondent places reliance on minutes of the hearing held on April 10, 2023, comma, annexed at page 80 of the stay application. Pushed up from the same comma, it is pointed out that the municipality had sought for a reduction of the bills of the appellant, but had not substantially denied the, its liability, Dana, its liability to pay such amount, and as such, comma, there is no scope of interference with the impugned order. Push up next para. It is next submitted by the private respondent that the writ petitioner acted with power of attorney given by the other partners, and as such, comma, represented the partnership firm itself. Full stop. Thus, comma, it is argued that since the writ court took one of the plausible views, comma, there ought not to be any interference by this court. Full stop. A careful perusal of the minutes of the meeting dated April 10, 2023, comma, which is the pivot of the adjudication, comma, shows that in the third and fourth paragraphs of the same comma, it was mentioned by the municipality that an inquiry was going on for taking further action in respect of the work done by the writ petitioner, stroke respondent. Full stop. It was stated that the sub-assistant engineer, comma, Mal municipality was instructed to make an inquiry in the matter and submit a report, but unfortunately, due to engagement in other official matters, the inquiry was not done by the sub-assistant engineer, and the matter remains pending since long. Full stop. The next paragraph starts with the word within double inverted, however, double inverted close, thereby qualifying the previous reference to the inquiry. Full stop. The municipality goes on to state in the said minutes that the sub-assistant engineer, comma, Mal municipality was not allotted funds for the work at the relevant time, and naturally the municipality has to pay the bill out of own source of fund. But presently the financial condition of the municipality was too bad, and the local body was unable to pay even the regular monthly salary, comma, wages of the employees since 3 months. Full stop. In the penultimate paragraph of the said minutes, comma, it was categorically mentioned by the municipality that in this position, comma, considering the opinion and financial position of the writ petitioner and also the financial condition of the municipality, comma, the chairman requested the writ petitioner to reduce the amount of the bill to rupees 17 lakh so that the payment may be made smoothly in 3 equal monthly installments to be started from July 2023. Full stop. Next para. The very request of the municipality to the writ petitioner stroke private respondent to reduce the amount itself shows that in principle, comma, there was no controversy to the liability of the municipality to pay such amount. Full stop. Next para. Thus, comma, although a pending inquiry was referred to by the municipality in the earlier paragraphs of the minutes, comma, at the same time, comma, it was observed that the same was pending since long and was subsequently qualified by the request of the municipality to reduce the amount due to the appellant, to the writ petitioner, comma, thereby virtually admitting the liability of for such amount. Full stop. Next para. In any event, comma, the view taken by the writ court was one of the plausible views, and in intra-court appeals, comma, this court ought not to interfere, merely to substitute its own views. Full stop. Next para. Insofar as the authority of the writ petitioner to represent the partnership, comma, we find that the partners of a partnership firm are not separate juristic entities from the partnership firm in the sense which is applicable to a company. Full stop. Next para. Since the petitioner all along claimed in the capacity of a partner and also submits that he was empowered by the other partners, and as no such objection was taken before the writ court as reflected from the impugned order, comma, we are not inclined to permit the present appellant to take
No,
such
my lord, we could not raise that dispute. It's part ex parte, your lordship.
ground at the present juncture, full stop, even keeping in view that the order was passed ex parte, comma, we are of the opinion that the petitioner is entitled as a partner, the writ petitioner was entitled as a partner to represent the firm. Full stop. That apart, comma, we find from the impugned order that the municipality was directed to clear the due amount for the work done by the partnership firm. Full stop. Accordingly, comma, the direction of the writ court should
No,
be
my lord, the
construed.
petitioner was not the partnership firm. Petitioner was the individual himself.
Accordingly, the direction of the writ court should be construed to mean that the municipality shall clear the due amount of the partnership firm which was represented by the writ petitioner. Full stop. However, comma, for such technical reason, comma, we are not inclined to interfere with the order. Full stop. Accordingly, accordingly, MAT 42 of 2024 and CAN 1 of 2024 as well as CAN 2 of 2024 are disposed of without interfering with the impugned order, but with the observation that the direction of the writ court for the municipality to clear the amount of the petitioner to the tune of rupees 25,06,962 oblique dash should be construed to be payable to the partnership firm which worked as the contractor of the municipality. No rest to cause.
My lord, only one thing, my lord, may I pray before your lordship?
Yes.
My lord, as that, my lord, resolution says that, my lord, I will be paying 17 lakhs in 3 installments if some installments be given to me, my lord.
Not
If that could
installment,
be
you
done.
pay within 2 months.
Within 2 months, my lord, kindly.
We'll give.
Expired service, they did not have it.
Yes, expert we are not. We are.
Expired service, they
No,
told
my lord, within 2 months, my lord,
to
kindly,
in
kindly.
both the writ petition.
No,
Kindly grant
court
that,
would have
yes, sir.
passed this order without directing notice. Obviously. আচ্ছা আরেকটা লাইন অ্যাড করে দাও শুধু অনিতা ওই যে however, comma, keeping in view the financial condition of the appellant municipality, comma, the dues of the partnership firm shall be cleared by the municipality in terms of the direction of the writ court within 2 months from this date.
Deeply obliged, your lordship. Deeply obliged.
I am for the appellant, Lanet DSJ is the online, your lordship, item
Lanet?
40, DSJ.
Lordship, Learned,
41 and
yes.
42, your
I am for respondent 1 to 5, Learned Advocate Devasis Kundu appearing virtually, your lordship.
What is the
Yes,
application?
Malad, I am for the appellant, Malad.
Lordship, am I audible?
Yes.
Malad is item number 42, I am for the appellant.
This is 41. This is 41.
Sorry, sir.
Mr. Kundu, you are, please unmute yourself.
We can hear Mr.
Mr. Mujumdar, yes. What is the application? The application is stay.
Actually, it concerns about the dispute of the land. But in our opinion, in the union's opinion, it is virtually a title dispute. My lord, I seek a very short time to annex certain papers and orders of the civil court, which will go to show what is the nature of the land and the devolution of title of the land.
So, Mr. Mujumdar will give you a fortnight's time to file a supplementary
My
affidavit.
lord, till
My
next
lord,
week.
I'm objecting, my lord, I'm objecting to that because by the admission of this thing,
Mujumdar.
but they see, he had categorically the writ petition itself. If your lordship takes up the order dated, my
Writ
lord,
petition, my lord, I am not concerned with the writ petition.
my lord,
My
he was
admission
there
is
in the
nothing.
writ petition.
My lord, then
his
let,
own
my
submission
lord,
has
hears
been
me for
recorded,
10
my lord.
minutes. My lord, hears me for 10 minutes.
My lord, before
Ask Mr.
that,
Kundu to
because
mute
they did
himself.
not
Let me
try
speak
to,
for
my
10
Mr.
lord,
Mujumdar, let
minutes.
Mr. Kundu take his point. Yes, Mr. Kundu, why are you objecting to supplementary
yes, my
affidavit?
lord. Your lordship only takes after the admission made by the Runner Deputy Solicitor General in the order dated 14th of December 2023 in the writ petition, does it lie in his mouth to make such a submission before your lordship? Your lordship only takes up, my lord. If your lordship got a get a
Mr.
copy of
Mr.
the writ
Kundu,
petition.
by permitting them to use supplementary affidavit, they are only bringing in facts. We are not adjudicating
No,
on the
no, my
merits
lord,
of the
your
matter.
lordship will not permit them. I'm saying why I'm telling your lordship. Your lordship, can you give me 2 minutes time
Yes.
to just show your lordship the manner in which the army authorities and the Union of India, in connivance with each other, has come to make a statement before the Lordship without taking into consideration the admission made by them by the learned Deputy Solicitor General which has been recorded in the order. And after that, he makes a submission. I'm
Mr.
ashamed
Kundu,
that
this is a subject matter of argument in the appeal. When we hear the appeal, that will be taken up.
Your Lordship will not allow here. May I make my submission?
Yes.
The order was passed by the single bench.
Yes.
Directing demarcation of a property.
Right.
Which was the subject matter of the dispute by the writ petitioner, wherein the writ petitioner has sought to make out a case that the army authorities, despite not having acquired the land,
Yes.
not having any title or with regard to the said land, had sought to sit over the matter, despite several requests to vacate the land. My land, then there was a direction by the court that the BL and LRO, Rajganj Municipality, Rajganj Block, should file a report. That was done so, no objection taken by the army authorities when the report was filed for the court.
Yes.
In the court, when the petition was disposed of,
My lord, we did not file any affidavit in Mr. Kundu's petition. Mr. I don't know, my lord, why he is so apprehensive? What is his fear if I bring certain documents on record? Is he afraid of something? Is he hiding something?
I am not hiding. You are trying to
Let me come with the document, then we'll see who is what.
Which have failed to do so.
Shouting nothing will do, my lord. We want to file certain documents to show the court what is the position of the land. Whether I have admitted something, whether I denied something, law is something and fact is something.
From second bench to second bench. From second bench to second bench, they have taken time. But Rajukali, here's me not for 5 minutes, and I'll show how the Union of India is working. Just because they appear on behalf of the Union of India, they're going to take law into their own hands.
Mr. Kundu, previously also they asked for this time. Asked for time.
7 times geological seas.
No, my lord, only last circuit we prayed for time. We came across certain documents.
Mr. Kundu, we find from the order sheet, Mr. Kundu, we find from the order sheet that on 13th of June, the appellant had prayed for time.
Yes, before prior that also, next agreement.
Yes, they have been repeatedly, yes.
No, my lord, this is only third day that appeal is coming up.
No, Mr. Mujumdar, on 3 occasions, either you were not present or you had paid for time. You are the appellants.
Yes, Lordship. My lord,
so
now,
on
my lord,
13th, Mr. Kundu is right. Why should he give you further time? You could have done that in the meantime.
Lordship, may I be permitted to speak for 5 minutes when Mr. Kundu had got 10 minutes time?
Yes.
Lordship, certain documents have come across our notice that will clearly demonstrate the nature status of the land and who are the persons entitled to claim in the land. My
Mr. Kundu,
friend, he knows
Mr. Mujumdar,
my lord,
by the impugned order, no right title was decided and could not be decided by the writ court. Only demarcation has been directed.
My lord, if this demarcation is done, then
yes,
somebody's title will be established.
No. Demarcation cannot establish title.
Because the lead petitioner is claiming as the owner of the land. Now, my lord, total land under the old plot number 353 was 25.80 acres.
Yes.
It was divided into 2 khatyans, 581 and 578. Each contained 12.40 and 12.40. Out of 25.80, 6 acres were acquired for the highway.
Yes.
My lord, we don't have any more 25.80 acres of land. We have now 25 minus 6 acres, is 19 acres of land.
Mr. Mujumdar, we are not deciding the title. Neither did the writ court decide. Only demarcation cannot, and we'll make it clear that demarcation will not.
Our prayer is let the demarcation also take in consideration of the RS plots.
RS plot. Yes, Mr. Kundu, there cannot be any doubt on that.
I have no qualms with regard to whatever the report. But one thing, my lord, the report which has already been filed by the BL and LRO, a copy of which was also given to my learned friend, They have never taken an exception to the report. And I would like to place my reliance
No,
on
we
the
have
report
not
itself.
taken exception then, so we are outed. We cannot say anything more.
Murad, if they, after 500, Murad, one thing, Lordship, may I ask a question to myself? Has
Yes.
Mr. Client has got claimed any right title or interest over the said land or not?
In a writ court.
Or on the contrary, your Lordship can take up the order dated 14th of December 2020.
Mr. Kundu perhaps has missed the line
where
that we
the
claim
order itself
12.48
records.
acres under our position since 1948 as a
So,
tenant.
so having possession, but I'm
Please ask,
absolutely shocked.
please,
to
my lord,
find
Mr.
that
Kundu may go
So,
to the
Mr.
court.
Mujumdar, Mr.
EFC
Mujumdar, if you did not take any exception, if you
My
did
lord,
not take any
our
exception
clear
before the writ
statement
court,
is we are holding the land from 1948
So,
under the state as a
so you
tenant.
become the owner. The
but
RTI itself
if you
says.
did not take out any exception before the
My
writ
lord,
court,
we
you
have
have
not
never
filed
taken
our
any
affidavit
exception
yet.
to the report.
My lord, we have not filed our affidavit yet.
Affidavit?
No, in the writ court, before the writ court, you did not take any
We have not filed
exception.
any affidavit.
In the writ court, you did not take any exception. Why should you be permitted to use affidavit? The
No, my lord,
reports,
this-
just because you are not permitted to file an affidavit does not mean that you could have taken this objection. The report, there is no finding that you have taken any objection to the reports. And we can make it clear that this will not establish the title of any of the parties. But not having taken exception before the writ court.
My lord, if Mr. Kundu keeps on speaking,
yes,
my lord, then my lord may dispose of these two appeals by allow me to take an exception with the report. We'll fight in the report.
Not today.
Let us see
for
if the
the
report
first
can
time
decide title.
after giving up his right,
But Mr. Mujumdar, you are there, you were present when the matter was
Yes, my lord.
taken up.
And my lord, the predicament is, my lord,
Yes.
highly appreciates all documents are not always given to the council by the department. Certain documents came across to me that clearly shows
Before the appellate authority, no, appellate court, no, Mr. Mujumdar, but we can make it clear that nothing in the impugned order shall vest right on anybody.
My lord, just allows me to take an exception before the trial court. I will fight it out in the trial.
No, Mr. Mujumdar, not at this stage. You did not take it before that court. For the first time in appeal on facts, no. If it was a legal question, we could have. Learned Deputy Solicitor General seeks leave to file a supplementary affidavit disclosing certain documents which have subsequently come to the notice of the respondent authorities. Full stop, next para. Learned Deputy Solicitor General argues that although no exception was taken to the reports of the BL and LRO, it is all the same true that no affidavits had been directed to be filed at that juncture. Full stop. Accordingly, it is contended that if the documents which have now come to the notice of the respondents, particularly the Union of India, are brought on record, the same may alter the outcome of the LIS. Full stop. Next para. Learned Senior Counsel appearing for the writ petitioner / private respondent argues that in view of the union having not taken any exception to the reports which were placed before the writ court, it is precluded at this juncture before the appellate court from taking such exception. Full stop. Next para. After careful consideration of the respective submissions of the parties, we find from the impugned order that the same was innocuous in nature, merely directing the block land and land reforms officer, Rajganj block, Jalpaiguri, to demarcate the LR plots mentioned therein and to supply the particulars thereof to the respective writ petitioners. Full stop. Learned Counsel for the private respondent herein is justified in arguing that having not taken any exception to the reports of the block land and land reforms officers which came before the writ court itself, a new stand cannot be taken before the appellate court by the Union of India for the first time. Full stop. However, at the same time, we are of the opinion that nothing in the impugned order could operate to confer any right, title, or interest on any of the parties. Full stop. Mere demarcation of the LR plots does not confer or take away any right, title of interest in such plots, from the rightful owner. Full stop. It may also be noted that the appropriate remedy in the case of any title dispute would be before a competent civil court, and the writ court's direction, which is impugned herein, does not hinge either way, comma, to create any right which any person does not have. Full stop. Accordingly, comma, we do not find any reason at this belated juncture to permit the Union of India to bring in further documents, comma, particularly in view of the innocuous nature of the impugned order as discussed above. Full stop. The writ court having taken a particular view on the basis of the documents which were on record and undisputed before the writ court, comma, we are of the opinion that no interference is called for and the appeal need not be admitted at all. Full stop. Accordingly, WPA 2392 of 2023 along with CAN 1 of 2024 are dismissed with the observation that nothing in the impugned order shall vest or take away any right, title of interest in favor of either of the parties. No dispute.
Lordships, only one indulgence may I permit. In this case, subsequently, your lordships, state government, DLRO, under the instruction of the DLRO, a proceeding under section 57 of WPLR Act has already been started in respect of the RS plot of 353, entire RS plot, and several person claim and made in party. Only your lordship, one line, if in this writ petition, your lordship, the order and the proceedings is continuing and is not.
We'll give a line that nothing in the this order or the impugned order shall affect any continuing proceedings.
Continuing proceeding in the 57 proceedings. Your lordship.
Where is the other side?
Other side, yeah, both state. Lordships.
My lord,
has been dismissed.
my lord,
Go back,
may I
Matt.
see?
Lordship.
So one other line has to be added. It is made clear that nothing in this order or the order of the writ court shall affect any pending proceedings before any forum stroke court.
My lord, may I seek one indulgence, my lord? Humble indulgence, my lord.
Yes.
Item number 37. I was all along in the last week at Jalpaiguri, my lord. Today, due
37
to
order
some-
has been passed already. Some order has been passed.
Item number 42, your lordship, is the same common order. Two
One minute. Lordship, item number 42, we have a different.
I am not there,
footing.
my lord. Separate
Mr.
responsibility.
Majumdar, you have a different case.
No, my lord. Actually, the writ petitioner before what we wanted to try to tell the writ court also, but we could not. Documents have come to show that the writ petitioner is not connected to the original landowners at all.
Writ petition was?
Writ petitioner is not connected to the original landowner.
Maybe.
Item number 42, we have filed.
So, my lord, if the
But
demarcation
the
in
order,
that.
impugned order is common in 41 and 42.
42, I am not there, my lord.
So this will govern that also.
Separate
That's why
responsibility.
you.
Mr. Majumdar, we have made it amply clear in several sentences that this will not affect the rights of any party or any pending proceeding. So 42 tact order record corner. Since the order impugned in MAT 45 of 2024 is a self-same order which has been impugned here in comma, the judgment and order passed in connection with MAT 45 of 2024 shall govern the present appeal as well. Second half, we will continue this up to 3. From 3 to 3:30, bail matters.
My lord, I beg to mention one matter for correction.
Yes, hand over the slip. Call on the list.
Lord, I am led by Mr. Milan Bhattacharya and Mr. Dilip Chatterjee in this matter. On behalf of respondent number 1. Lordship, in this matter, Mr. Shishana Bandyopadhyay appeared through virtually, Lordship.
Is for the appellant.
We are for
Well,
the appellant, Lordship, state.
I
Yes.
beg to appear for the appellant, my lord. I am online, my lord.
Yes, Mr. Bandyopadhyay, what is the matter?
My lord, the matter, my lord, your lordships will find, my lord, in the impugned order, a direction has been given to pay compensation to the person whose property was supposedly taken to construct a pump house of the State Department.
Yes.
That is the PHE department.
What are the two applications, Mr. Bandyopadhyay? Two
My lord,
applications?
one application, my lord, is for stay, and the other application, my lord,
Section 5, Lordship.
Section
5,
5.
my lord.
Section 5, what is it? Let us condone that first. What is the delay?
Yes. My lord, the delay is of 56 days.
What is the reason given?
My lord, the reasons is my lord, the certified copy that was obtained by us on 14th of December, and though it was, my lord, applied a bit back, my lord, but not within the period of limitation which is allowed. So, my lord,
Mr.
there was
Bhattacharya,
a-
you condoning the delay first, then taking up the matter? Mr. Bhattacharya, you muted probably. এদিক থেকে mute করনি তো? Your mic is muted, Mr. Bhattacharya. Ask Mr. Chatterjee to, or whoever is there. Can't hear you. Mr. Bhattacharya, we can't hear you. Your mic is not functioning probably.
my lord,
My lord, now you also can't hear me?
Yes, now we can hear you. What about the section 5? Okay, should we allow that and then proceed?
My lord, affidavit in opposition has been filed by us.
Regarding section 5?
Section 5 in affidavit in opposition. Yes, section 5. We have filed a section 5 affidavit in opposition to the section 5 because it is not maintainable at all, because the delay has not been condoned, because law says sufficient cause has to be shown. No sufficient cause has been shown, no
Lordship, kindly
dates.
directed
pleading.
them to supply a copy to us, Lordship.
Lots have been
Mr.
stated.
Bhattacharya, no copy of the opposition has been given to the other side.
no, I have also not received any opposition, my
No,
lord.
it was not given. It is being given now. Was there a direction for filing opposition?
No, I doubt, my lord, because on the last petition it was
Yes.
adjourned because service was not being accepted by the writ petitioners.
Acha.
In the application, they have stated in paragraph 15, 16, 17, 18, 19,
Yes.
without any particulars. They say, just quoting from some judgment of the Supreme Court, they have stated, made their statement in the paragraph 16, 17, 18, 19. No particulars have been given. When applied, who applied, how it has been sent, how the particular officer came, no particulars. Only bold statement has been made.
Mr. Bhattacharya, we won't be hyper technical in section 5. We will consider your opposition, but we will allow the application.
Sufficient cause shown for the purpose of condonation of delay. As
Yes,
said,
Mr.
Madam,
Bhattacharya, we will allow the
my-
application. We will take
delay
note of
cannot
your
be
opposition.
considered. It is 68 days delay, not 56. It is 68 delay, 68 days delay. We have stated in our affidavit in opposition. No explanation.
Affidavit in opposition filed by the respondents to the application for condonation of delay is filed in court and is kept on record, comma, although there was no previous direction for filing such affidavits. Full stop. A copy thereof is handed over only here and now to the learned advocate for the appellant, stroke petitioner. Full stop. Upon careful learned senior counsel appearing for the respondent contends that no particulars have been given in the relevant paragraphs of the condonation of delay application, and as such, the application ought to be dismissed. So that apart, comma, although the delay has been mentioned as 56 days, comma, the actual delay in preferring the appeal is of 68 days. Which of next para, heard learned counsel in connection with the application under Section 5 of the Limitation Act, full stop. We find from the explanation given in paragraph 15 onwards of the application that the delay was due to jurisdictional changes of the subject matter from High Court at Calcutta within, principal bench to the circuit bench at Jalpaiguri, and that the registrar of the circuit bench, Jalpaiguri, had intimated that the records were lying with the principal bench and could not be and should be forwarded to the circuit bench for filing an appeal. Full stop. Due to such jurisdictional changes, the delay has been the condonation of the delay has been sought. Full stop. Upon perusal of the application and the opposition, we are of the view that sufficient cause has been shown in the application. Full stop. Application for condonation of the delay occasioned in preferring the appeal. Full stop. Moreover, it is well settled that hyper-technical approach is not taken while considering such applications. Full stop. Accordingly, can 1 of 2024 is allowed, thereby condoning the delay in preferring the appeal bearing MAT 56 of 2024. Full stop. The appeal is now taken up for hearing, for admission hearing. Full stop. Yes, Mr. Bandyopadhyay, what is the case?
My lord, the case in a nutshell is that, my lord, we have come against a direction to pay compensation to the petitioner because her land was supposedly utilized by us. Not supposedly, it was actually utilized by us, by the PH department, to construct a pump house.
Yes.
But the fact remains in this case that, my lord, if we go back in time, apart from the delay of the writ petitioner in approaching the High Court, which I'll address later, my lord, there was a scheme. It was an accelerated urban water supply scheme, which was to be funded by the central government and 50% by the central government and 50% by the state government, including a 5% contribution by the beneficiary. Beneficiary here meaning the Gram Panchayat. Now, when the scheme was implemented in the particular area, what happened? The Gram Panchayat was accordingly asked to contribute as a beneficiary of the pump. Now, in lieu of that, the Gram Panchayat writes to us that in place of the monetary contribution, we'll give you a parcel of land where you can construct the pump house. Now, on the basis of that assurance, my lord, we construct the pump house and it has been functioning on and from 2008. After about 4 years, the entire action of the writ petitioner starts by writing letters, etc., saying that my land has been utilized without any consent from my side. And my lord, 2 decisions have been relied on by the honorable single judge. But my lord, my humble submission is that these 2 judgments, though may be appropriate law as far as payment of compensation is concerned, both the judgments do not take into consideration a fact situation where a consent is given by the Pradhan of the area, Gram Panchayat, and on the basis of that, the state starts acting. And after a long period of delay, the petitioner comes and says that no consent has been taken from us. Now, my lord, this is the facts in a nutshell. Now, if I may place the documents, if your lordship kindly start from page 110, which is the scheme.
But the land of the petitioner was, writ petitioner was given by the committee.
Land of the petitioner was given by the Gram Panchayat.
Gram Panchayat. Then the petitioner cannot suffer for that, Mr. Bandyopadhyay.
But at the same time, my lord, it was the beneficiary's contribution in lieu of which the land was given to us by the Gram Panchayat. Because we had written to the Gram Panchayat, when I take your lordship through the documents, your lordship will find we had asked for a firm commitment from the Gram Panchayat that you want to be a beneficiary in this scheme. In lieu of that, a land is given to us. Now, my lord, what arrangement is between the Gram Panchayat and the petitioner, we do not know. Even the honorable single judge has not delved into that aspect at all, but is settling the state, my lord, with the direction that a compensation is to be paid to the petitioner. But if at all the land is utilized in lieu of money by the Gram Panchayat, it is the Gram Panchayat which has to compensate the petitioner. It has nothing to do with us. Or as a matter of fact, it has nothing to do with land acquisition as such.
But Mr. Bandyopadhyay, you took it under a scheme, maybe, but vis-a-vis the petitioner, from the perspective of the petitioner, it is you who utilized his land or her land, and you should compensate otherwise also and recover some from the Gram Panchayat.
My lord, the beneficiary committee here was constituted in 2002. The Gram Panchayat writes to us in 2003. The work is completed in 2005. Everything is happening, my lord, under the nose of the petitioner. My lord, in 2012, the petitioner for the first time says that I acquired knowledge that my land has been utilized. But kindly, my lord, goes through the documents and kindly sees, my lord, time and again the state told the Gram Panchayat the firm commitment is required from your end as you are the beneficiary. My lord, this particular project has nothing to do with land acquisition because the beneficiary said that I am giving a land out of our own volition.
But that land belongs to somebody else. You ought to have been cautious while taking the land. You ought to have ascertained that it was actually available to the Gram Panchayat. It was your product also. Yes.
Malad, the cause at all, if at all was there, Malad, we have not gone on the route of land acquisition because land was being given voluntarily by the beneficiary in lieu of the money of 5% which was to be paid.
No, somebody else's land was given and you took it merrily, Mr. Bandyopadhyay. Somebody else's land was given. You should have ascertained who is the owner.
Malad, that cause arises, Malad, of the petitioner against the Gram Panchayat. Kindly sees this. Kindly sees the documents of the
Petitioner is not bound by anything. Petitioner's land was utilized by you. You have to compensate and you can recover that money, whichever loss you suffer from the Gram Panchayat. Petitioner need not suffer for that.
So, Malad,
petitioner is not bound by either the scheme or by any document between you and the Gram Panchayat. Petitioner is not bound.
Malad, even the Malad Honorable Single Judge did not go into the aspect, Malad, and did not ask the Gram Panchayat how the land was offered to the state. Malad, this query was never put to the Gram Panchayat, Malad, and without this query, Malad, the state will be saddled with the compensation part. And Malad, also the state let go of the beneficiary part at that point of time. Now the state will also have to pay for the land. So, Malad, it is double jeopardy for the state, Malad.
No, you don't have to pay. No, you don't. It is not double jeopardy. You have to pay compensation to the landowner, but you can recover that. We'll make it clear. We'll furnish further reasons and we'll say that we agree with the conclusion, but the reasons we are supplying that this does not prevent you from recovering the loss from the Gram Panchayat. But the fact that the petitioner you utilize the land, petitioner is not a party to any of these agreements between you.
No, Malad, but the difficulty is that, Malad, the order, if your lordship kindly see paragraph 18 of the order impugned, which is, Malad, Malad, from either the stay or the memo, if your lordship kindly take
we have got it.
18, kindly see, Malad, along with that, Malad, it is the Honorable Single Judge directs us that she is entitled to compensation for the same, along with other statutory benefits, including solatium, interest, etc., treating it as a case of deemed acquisition. In other words, the property of the petitioner is deemed to have been acquired by the state. Acquired by a state, and the petitioner is entitled to compensation and other statutory benefits for the same. So, Malad, the color is completely different. The color is that of a land acquisition. And that is why, Malad, I was, Malad, praying to place the scheme, because the way the correspondences happened between the Gram Panchayat and the state, there was no question of any land acquisition at all. But we could have done so. Had the letter, if I put it this way, had the Gram Panchayat not misled us this way, I do not know whether there's a collusion between the petitioner and Gram Panchayat or not, Malad, because I cannot show any document to that extent. It can only be a rough guesswork. But, Malad, that is why I'm putting in a way that the Gram Panchayat has misled us. Had they not misled us, we would have taken the route of land acquisition, no problem at all. But today, after so many years, that almost 22 years of inception of the project, we are facing a situation where the land is to be treated as deemed acquisition without the requirements of the statute under section 4, section 6, etc., etc. So, Malad, even if your lordship, Malad, I bow down to the Malad, what is falling from your lordship, the order your lordship proposes to pass, Malad, that I can recover it from the Gram Panchayat. Firstly, Malad, this solatium and interest part, Malad, it should be treated as land at a market value, like in direct purchase policy. And secondly, to assist your lordship in passing that order, if I may place the documents, Malad, as in a shortest possible time.
Yes.
So, Malad, if your lordship kindly, Malad, starts from page 110, which is the scheme.
110, yes.
110. The scheme is starting from 106.
Right.
Malad, this is the pattern of finance. Roman 10.
Yes.
That the accelerated urban water supply program bring a centrally sponsored scheme. This will be funded on grant basis by the central government 50% and state government 50%, including 5% beneficiary or town contribution. In case of union territories, 100% financing, so on and so forth. Then Malad kindly takes page 162. Malad, 162.
Yes.
Top 5 lines, which is
Right.
part of an affidavit which is filed by us, will give your lordships the date that
Yes.
162 top 5 lines.
Right. Right.
That a major portion of the water supply project was completed long back in the year 2008, and the service connection charges for drawal of power line for effecting new service connection at Ukto Latabari water supply scheme were paid on 2nd of July 2008. Then paragraph 8 of the same page. It is apparent from the letter dated 18 February 2009 that the construction of pump houses was completed on petitioner's land in 2008 and power service connection charges were paid in July 2008. The petitioner cannot deny her knowledge about these facts. Then, my lord, kindly, if your lordship takes
162
page 42.
162.
Page 42 is part of the writ petition.
Page 42, yes.
Yes. My lord, page 42 will show that the petitioner claims that the petitioner knowledge came in 2012. Paragraph 4 kindly
Yes.
takes
Yes.
all on a sudden, the respondent authorities asked the petitioner to submit relevant papers and documents relating to the possession and ownership of the scheduled land in question for its acquisition to work under the project of Uttol Latabari water supply scheme, and on basis of the requisition of requiring body, LAC, that is land acquisition collector, I suppose, he submitted these said documents on 3rd of January 2012 in the office of the assistant engineer, so and so and so and so. So petitioner claims the knowledge to be from 2012, that she had no knowledge when the entire thing was being taken place.
But the acknowledgement mentioned received application of requiring body LAC for acquisition of land. So your receipt said that also.
Yes, but here the mistake that we have committed is that the assistant engineer there suddenly in 2012 thought that some steps are to be taken with regard to the land. That is in 2012.
But it's literally a costly mistake.
Very, very costly mistake as we find now. Now, my lord, your lordship will then kindly be pleased to take 4 more documents which are very vital to my case. Kindly take page 114.
114.
Well, this is the letter by the Latabari Gram Panchayat which I was talking about.
Right.
Well, this they had given to the PHE department. Kindly see the subject: land for headworks site for proposed water supply scheme of Uttol Latabari. In reference to the above, undersigned likes to inform you the following land is selected for headwork site. Owner of land is Suchitra Roy, that is the writ petitioner. Page 114.
Yes.
And the plot number is given as 355.
Was an extension given by them as to how they came in occupation of the land, or how was it?
No, Malad, we get this letter at 114, and we also get another resolution at page 119, which shows that the Gram Panchayat is offering the land to us. Malad,
But you should have ascertained, Mr. Bandhavade, you should have independently ascertained. Without that, how could you take a land of somebody? I mean, you had to ascertain at least that it belonged to the Gram Panchayat.
Now, Malad, they had at 114, I find that they had given some enclosure of land documents. Now, we are so far back in time now. Malad, this is of 1999. We are in 2024, Malad. Malad, even we could not ascertain what Xerox copy of land documents the Gram Panchayat had given to us way back 25 years in 1999. But your lordship will find at page 114 bottom that some land documents were given to us by the Gram Panchayat at that point of time.
Was a Panchayat also a party to the writ petition? Must have been.
But Panchayat was subsequently added because I find from the cost title that
Right.
it's handwritten. Panchayat addition is handwritten.
So Panchayat was unrepresented. I mean, apparently so. We don't find any version of the Panchayat.
There is no appearance as far as Panchayat is concerned.
Mr. Bandyopadhyay, we are being candid. There are two things against you. One is that, yes, you ought to have satisfied yourself that the land actually belonged to the Panchayat which was giving it to you. There is nothing of that sort on record, at least.
Right.
Secondly, your engineers, that costly mistake of your engineer. So coupled together, there was some basis of the learned single judge's order. Why should in an intra-court appeal, should the writ court, the division bench interfere, Mr. Bandyopadhyay? Why should we interfere in this?
Kindly, do not take me amiss, but
Yes.
the requirement to ask the Gram Panchayat that why was this, because we are, the Honorable Single Judge is coming to a conclusion that this should be a deemed acquisition, giving a go by to all the statutory requirements of land acquisition. For coming to that, this question that is being posed, that is falling from your lordship, and I am really grateful for this question, but this question is absolutely absent in the Honorable Single Judge's consideration, that how the land came to the state. Well, it's one thing to say that the state did not look into the documents at that point of time, but we are talking about a situation 22 years back.
Mr. Bandyopadhyay will furnish the reasons.
Happened.
Give the poor person his dues. We will furnish reasons.
Let it be on market. I bow down to what is falling from your lordship. Let it be on market value as a land purchase, direct land purchase on market value, because this was not an acquisition at all. Kindly see these two documents. This 114 I've already placed where Gram Panchayat proposes the land to us. Then it takes 115. I'll just show three more documents.
Yes.
115.
Yes, 15.
115, first paragraph.
115.
115, first paragraph. It's a memo of 2002.
Right.
It is an administrative approval of 5 water supply scheme for Uttar Latawari. The undersigned is directed to forward herewith a buff sheet with a copy of so-and-so along with its enclosures on the subject cited above to state that the Government of India has already approved the scheme with some technical points, and Development and Planning Department has requested to re-examine the proposed scheme with their present proposal, as beneficiaries must contribute a share of the capital cost of the scheme. A detailed discussion may be arranged with the local body, and a firm commitment from that beneficiary local body may be obtained in writing. So this was the position in 2002. We asked the Gram Panchayat also in tune of 2002 that you give a firm commitment regarding this beneficiary arrangement. Then 117 kindly takes, my lord.
Yes.
In 117, your lordship will find it is also an administrative approval which was given to the Shabapati of the
This is
Kalkini
between the
block.
Panchayat and you. This is between the Panchayat and you.
Yes.
We'll ask Mr. Bhattacharya 2 questions. Mr. Bhattacharya, we can come back to Mr. Bandyopadhyay. Mr. Bhattacharya, we don't contemplate any interference at this stage, at any stage. I mean, instead of interference, there will be 2 modifications we may give subject to hearing you. One, that there cannot be any deemed acquisition. That is an unknown concept to law. Yes, the learned single judge was justified according to us in directing state to pay compensation. We shall add that the state is entitled, nothing in this order shall prevent the state to recover it from the Panchayat, which does not affect you. And secondly, Mr. Bhattacharya, since there was no acquisition, no procedure of acquisition at all at any point of time, and you committed some delay, we shall ensure that you get compensation at the current market rate instead of the solatium and all this thing. Like a direct purchase, as Mr. Bandyopadhyay said, the current market value will be assessed and you will be paid full compensation at the current market value as it is a purchase from you as on current date. What do you say to that? Only this modification.
So far this case is concerned.
Yes, Mr.
The particular acquisition, particular user of the land was made by the public health engineering, and that is the project. That is a project under Government of India and State of West Bengal. 50% and 5% from the beneficiary persons. Now the resolution of the beneficiary, you lordship can see some political person took a decision, page 118.
Page 118, yes.
Some political
Yes.
person took a decision that my land would be handed over. Their
But
land
that
should not be handed
justifies the
over. My
contention
land
of the
would be
state
handed
that
over.
those political persons belong to this Panchayat Samita and your remedy lay
They
before
are
the
not the
Panchayat.
person competent to hand over my land. My land under
True.
Article 300, my land will remain with me. I am a retired person.
Mr. Bhattacharya, we have no doubt. We have no
As such,
doubt
my
on that.
government started.
Your land was given by the Panchayat. That could not have been done. So there is a justification is in Mr. Bandyopadhyay's contention. Then your remedy lay before against the Panchayat, not against the state. But we gloss over that because you are a land loser. Your land has been taken, and you are entitled to compensation for the time being. Will so that you do not have to run from pillar to post between the Panchayat and the state. Then we'll give you compensation. But this deemed acquisition concept is not there in law. So there cannot be a deemed acquisition and solicitation and all. They'll directly outright pay you direct purchase price at the current market rate. We'll modify it to that extent and direct them to prove that market value. They make the assessment and pay the current market value to you within a limited period, maximum 2 months.
My submission before you know, kindly see the judgment. In the judgment, 2 judgments of the Supreme Court have been considered with regard to points involved in this case. Kindly see the judgment, madam.
No, those are regarding delay and laches. We said, as we said, we glossed over the delay. We are glossing over the delay. We are not taking into account your delay. Those judgments are on delay. We agree.
Supreme Court said I am entitled to compensation. Because
You are entitled to compensation.
Recourse to law.
But Mr.
Beneficiary
Bhattacharya, that
committee
cannot be
authority.
as per
It
Land
is not a
Acquisition
statutory
Act
authority.
standards. Because Land Acquisition Act is not applicable here.
Beneficiary committee is not a statutory authority, madam. They cannot take my land even unless this is taken by the Section 4 of the Land Acquisition Act. And
Agreed
as
on
the proceeding
everything.
has been
But here
started,
there was no land
65
acquisition.
Lord Kandisi.
Your land was taken as long back as in 2012 you came to know. And you come up when? Much later, 5 years later than that.
Can you see the page 65, my lord, can you see the Land Acquisition Department?
Yes.
Page 79.
79 or 65?
79, can you see, my lord? Submission of land acquisition documents under Uttol Lotabari West Bengal water system scheme, page 79. They started the proceeding to hold the acquisition proceeding and application for hearing body, ammonia print of such and such, various letters have been written by the governmental authority.
Your plot number is 355, Mr. Bhattacharya. 355 is your plot number.
As such, secretary said,
Yes,
as
yes.
such, my lord, page 85,
Uh-huh.
to furnish a status report regarding the matter. Can we see page 85?
Yes, yes, yes.
Secretary said that my prayer has to be considered by the Land Acquisition Department.
Right, right, right. All right, all right, all right.
Gardening competition.
All right, we understand. Yes, Mr. Bandyopadhyay, what about these documents?
My lord, your lordships will kindly find, as I showed, as I was reading from the pleadings, that
So
this
these
starts
proceedings
from
already
page
taken.
31. This
No,
is
no.
the letter of the assistant engineer.
No, but
Page
no, not
31.
that, not that. Page 79, 80, 81. There was a cabinet approval for land acquisition, including their plot. Full-fledged proceedings were taken out by you. Please see from page 79 onwards.
Yes, yes, my lord.
So then you undertook proceedings. You initiated proceedings for land
No,
acquisition.
my lord, there was no section 4, there was no section 6 in this case.
No, even then.
In fact, the prayer for compensation, your lordships will find at page 85, the typed copy. Page 85, the typed copy, the prayer of Suchitra Rai for getting compensation are asked in question of land. The prayer for compensation started from the side of the petitioner.
Maybe, but Mr. Bandyopadhyay, you undertook, you initiated proceedings for land acquisition, and therefore there was a tacit consent that yes, land acquisition is required. How can you resolve from that position?
Well, all these documents are by the executive engineer who is no way connected with any land acquisition. It is the executive engineer who is writing to the land acquisition collector saying that you initiate land acquisition proceeding for no reasons at all. for no reasons at all. This is
Of
absolutely
taking my
oblivious
lands,
of
my
what
lord.
is happening.
No, no, you
Absolutely
cannot disown your
oblivious
own
of what is
officials.
happening
No.
with the Gram Panchayat. No, I'm not disbelieving. My lord, what I'm saying is that this is without consideration, being oblivious of the whatever happened between the Gram Panchayat and the state at that point of time.
No, Mr.
Your lordship will not
Bandyopadhyay.
find any reference of any beneficiary committee, anything.
No, Mr. Bandyopadhyay, no interference. We'll give our
My lord,
reasons.
kindly see
Sorry.
page 82. Cabinet
No, we'll
approval has
give
not
our
been
reasons. No
explained by
interference
them.
with this order.
Their own document.
Yes.
Page 82. Kindly see cabinet approval.
The appeal is
Yes,
taken
sir,
up for
it
hearing.
is
First up,
approval
learned
necessary
counsel for the
for the purpose of
appellant
acquiring my land.
stroke state
I'm a legal
submits.
person.
Learned counsel for the appellant.
By only political
Mr.
gesture.
Bhattacharya, we are passing our order. We are not interfering. Learned counsel appearing for the appellant submits that the land of the petitioner was not acquired under the Land Acquisition Act, but was offered by one of the stakeholders in the Accelerated Urban Water Supply Program of September 1994, under which the local Gram Panchayat offered the land of the petitioner to the appellant authorities for the project in question. First of next para, it is contended by placing reliance on the provisions of the scheme, in particular clause Roman 10 thereof, that the pattern of finance was that the Accelerated Urban Water Supply Program brings a centrally sponsored, being a centrally sponsored scheme, will be funded on grant basis by the central government 50%, state government 50%, including 5% beneficiary stroke town contribution. Full stop. Next para. Learned counsel also places reliance on relevant documents annexed to the stay application, in particular a communication by the Latabari Gram Panchayat dated October 13, 1999 to indicate that the land in question pertaining to plot number 355 was offered to the appellant authorities by the Gram Panchayat itself. First up, by placing reliance on the memo dated June 5, 2002, annexed at page 115 of the stay application, it is argued that the Deputy Secretary of the Government of West Bengal proceeded on the premise that the land was being offered under the scheme in question by the concerned Gram Panchayat. First up, next para. It is thus submitted that the learned trial judge, while passing the impugned order, committed a gross illegality in directing compensation to be given by the state, whereas the remedy of the writ petitioner, for compensation, if any, lay at best against the concerned Gram Panchayat. First up, next para. It is secondly argued by the appellants that the acquisition never took place under the concerned Land Acquisition Act, and as such, the learned single judge erred in law in applying the modalities of acquisition of land under the Land Acquisition Act in directing compensation to be paid to the writ petitioner. First up, in paragraph number 18 of the impugned order, it was recorded by the learned single judge that the writ petitioner is entitled to compensation along with other statutory benefits, including solatium, interest, etc., treating it as a case of deemed acquisition. Full stop. In other words, it was held, the property of the petitioner was deemed to have been acquired by the state, and the petitioner is entitled to compensation and other statutory benefits for the same. Full stop. Learned counsel submits that apart from the fact that the land was never acquired by the state but obtained under the scheme from the Gram Panchayat, fact remains that the writ petition made a grossly belated claim for compensation, and as such, ought not to have been permitted, ought not to have been granted the relief by the writ court at all. Full stop. Next para. Learned senior counsel appearing for the private respondent stroke writ petitioner places reliance on certain documents annexed to the stay application as well. Full stop. Learned Senior Counsel points out that by a letter dated February 14, 2012, comma, the executive engineer, comma, Jalpaiguri division of the PHE, comma, which admittedly utilized the land in question, comma, wrote to the special land acquisition officer Jalpaiguri with regard to acquisition of the property. Full stop. Again, comma, approval for land acquisition for Uttar Latabari was mentioned as the caption of another notice of the same executive engineer to the land acquisition collector dated February 6, 2014. Full stop. Next para. Learned Senior Counsel places several correspondences annexed to the stay application from the same authority to indicate that initiatives were taken by the appellant's authorities themselves for acquisition of the land. Full stop. Next para. As such, comma, it is argued that at this juncture, the appellants cannot resile from such position and deny the entitlement of the writ petitioner under the concerned provisions of the Land Acquisition Act. Full stop. Also, comma, a receipt was annexed to the writ petition dated January, a receipt dated January 3, 2012 was annexed to the writ petition, comma, from which it transpired that it was acknowledged that an application of the requiring body LAC for acquisition of land for Uttar Latabari water supply scheme was issued in favor of the petitioner. Full stop. Next para. Thus, comma, it is submitted that the learned trial judge was fully justified in passing the impugned order. Full stop. Insofar as the argument of delay is concerned, comma, learned Senior Counsel places reliance on the judgments of the Supreme Court, which were relied on by the learned single judge in such context. Full stop. It was observed by the learned single judge on the premise of such judgments that delay and laches cannot be raised in a case of a continuing cause of action if the circumstances shock the judicial conscience of the court. Full stop. Condonation of delay is a matter of judicial discretion which must be exercised judiciously and reasonably in the facts and circumstances of the case. Full stop. Next para. Upon a careful scrutiny of the materials on record and hearing learned counsel, comma, we are of the opinion that the scope of interference in an intra-court appeal is limited. Full stop. Next para. Seen from such perspective, comma, there was sufficient reason for passing the impugned order by the learned single judge. Full stop. Next para. It might very well have been that the state had obtained the writ petitioner's land pertaining to plot number 355 from the local Gram Panchayat under a particular scheme. Full stop. However, comma, fact also remains that the said scheme did not bind the writ petitioner, comma, the latter not being a party.
Page 156.
The latter not being a party to the same.
156.
Full stop. Next para. We further find that the entire corresponding pertaining to the offering of the land, pertaining to the offer of the land by the Gram Panchayat in favor of the state, comma, for the purpose of utilization by the PHE, comma, did not find any participation of the writ petitioner at any point of time. Full stop. Next para. As such, comma, the writ petitioner could not have been bound by the said scheme or the modality by which the state obtained the land. Full stop. Next para. That apart, comma, we are of the further opinion that the state, comma, before taking the land, comma, ought to have satisfied itself properly by analogy to the principle of caveat emptor within bracket, although not directly applicable, bracket closed, that the land being offered by the Gram Panchayat actually belonged to it. Full stop. Next para. Although there are certain cursory references to documents having been furnished by the Gram Panchayat to the state in that regard, comma, there is no mention at all in the documents which are before this court as to there being any attempt on the part of the state or the uh, PHE to satisfy themselves as to the title of the land before taking the same on the offer of the Gram Panchayat. Push up next para, that apart, comma, the PHE cannot now disown the repeated acts of its own executive engineer at the contemporaneous juncture. Full stop. It is seen from the several correspondences of the relevant time that efforts were made on the part of the PHE to acquire the land. Full stop. Next para. The same is also borne out by the acknowledgement which the petitioner annexed to the writ petition. Full stop. Next para. Thus, comma, although there is no concept in law of deemed acquisition, comma, we are of the opinion that the learned single judge was perfectly within jurisdiction in premising the modality of assessing compensation on the parameters of land acquisition, comma, since the appropriate course of action for the state was to adopt the modalities as enumerated under the Land Acquisition Act for the purpose of acquiring the property of the petitioner. To stop next para, having not done so, comma, the parameters and yardsticks of the Land Acquisition Act are the only guideline which can be applied for assessing the compensation payable to the writ petitioner. Push up next para. In such view of the matter, comma, we are of the opinion that although on the given fact scenario, comma, an alternative view in favor of the appellants might have been possible, comma, the view taken by the writ court was also one of the plausible views, and we cannot upset such views and substitute our own in place of the same in an intra-court appeal. Full stop. Next para. In such view of the matter, comma, we are not inclined to interfere with the impugned order. Accordingly, Mat 56 of 2024, along with Can 2 of 2024, are dismissed without any order as to cost.
But I believe the liberty to
Sorry. Yes.
the amount from
Yes.
Gram
Yes.
Panchayat is
It
also
is,
not being given.
yes, you are right. It is made clear, comma, however, comma, that nothing in this order and or the order of the learned single judge shall preclude the appellants herein from taking out appropriate proceedings against the concerned Gram Panchayat for recovery of the money which the appellants shall pay to the writ petitioner in the event the appellants can establish that they have a right in law to do so, comma, unfettered by any of the observations made above.
Great, Sumala.
Thank you.
Great, Sumala.
Thank you, Mr. Bhattacharya. Yes. Affidavit service be kept. Yes. Next. Doctor. Not to take order. Forty-four has been made not today. Nobody responded.
45 playing for next circuit.
Your Lordship,
45?
item number 45, I am appearing for.
You are for the?
Appellant, my lord.
On the prayer of the appellant, 45. On the prayer of the appellant, let them attest and adjourn till the next circuit. Yes, next. Yes, what is the matter? Mr. Mishra, you are for the respondent?
I am for the respondent.
Right.
It's a GST matter, my lord. There
Next
is
circuit.
continuation of delay-
We don't know anything about GST.
Continuation of delay application. my lord.
Continuation of delay, we know everything about one.
No, sir. There is a serious objection of the.
Oh, to the condemnation also?
On the condemnation, the grounds have been suppressed. What? 2 minutes.
Achha, let us see the condemnation.
But the information is that he fell in the washroom. And that has been grossly suppressed here in here.
No, illness and washroom may be related also.
That has been disclosed. Hasn't been discussed. Was ill actually. He fell down in the bathroom and there are.
Well, in view of sufficient cause having been shown for the delay in preferring the appeal, can 1 of 2024 is allowed, thereby condoning the delay in preferring MAT 61 of 2024, full stop. Let the appeal be
Just one request, my lord.
duly registered.
Writ petition has not been enclosed. Is it possible, my lord, that the LCR, the writ court records are called for, my lords?
Yes, because we'll take up the appeal afterwards. In the next circuit, it will take.
Let the
আচ্ছা আরেকটা লাইন অ্যাড করে দাও যেটা বললাম তারপরে অ্যাড করে দাও যে the lower court records be called for full stop in view of appearance of the respondents the requirement of further notice is dispensed with and the appeal be treated to be appeal be treated and কথাটা কেটে দাও the parties shall prepare informal paper books and file the same upon exchanging between themselves, before the hearing of the appeal, full stop, such preparation of paper book shall be done by the appellant within a fortnight, within 4 weeks from date. Full stop. Let the liberty to the parties to mention the matter before the appropriate circuit after 4 weeks.
I'm deplored.
Next. Yes.
Madam, item number 47, I am appearing.
40 কত রাখলে?
47.
Yes, 47. Yes, Mr. Deborman.
Yes, Madam, the order under challenge is of dated 20th of May. That
Yes.
start from page 77. Madam, before I draw your lordship attention to the order as a whole, I am just giving my 3 points. Number 1, this order has overreaching effect over the earlier order dated 9th April passed by the coordinate bench. That 9th April order, if your lordship will get at page 68 to 9th April order is page 58 to 60. But by this order, I'm giving a short fact. Just in front of the appellant's house, there was a highway, state highway. That state highway land was encroached illegally by certain persons. Initially, I moved the petition in WPA 606. That was disposed of by the order dated 9th April 2024 with a very specific direction that if there is encroachment, because there was a stand of the state that by a report dated 5th April, lordship kindly take note of the date of report dated 5th April that the encroachment was removed. But it was made clear by the order dated 9th April that even if it is found that encroachment is not removed, that should be removed. Accordingly, the authority of the state authority, my lord, having the statutory obligation under section 10, issued the notice that is notice that is the order that we found page 56. That page 56, the 24th April 24, the authority exercising the statutory power under 10(1) directed the private respondent petitioner to remove the encroachment which was identified by the authorities by 10 days from the order from the notice dated 24th of April 2024.
Yes.
Now, very cleverly, what they have done, they have made an application, so-called applications under section 8(1) of the Highway Act, West Bengal State Highway Act, for granting them permission. But section 8(1) is not at all applicable because of the fact that lordship, if your lordship kindly come to page 61, that from the first paragraph of their representation, it reveals that their case is that they are continuously, my lord, running shop over there and they want to continue. But section 8(1) is for temporary period. Like we have the experience that melas are being happened, the fairs are being happened, for that 6 days, 5 days permissions are being given. But this section 8(1) is nothing but a perverted attempt to drag the matter. And on the basis of this, they have filed the writ petition, the order of which is under challenge. The Honorable Single Judge passed an order on 20th May by directing the authorities to consider their application under section 8(1).
though, my lord, it is admitted fact that they have not challenged, in spite of having their knowledge, the petitioner respondent herein have not challenged the order dated 9th April and that order reached to its finality. But they have made a case that they have made an application under Section 8(1) for, my lord, continuous perpetual possession. Section 8(1) is not for the perpetual possession, that is for the temporary, my lord, permission.
Mr.
And the-
Devarman, Mr. Devarman, the last part of the impugned order says, the learned single judge said,
Yes,
no
yes,
effect
yes.
shall be given to. No, no, we have seen that. No effect shall be given to the impugned order dated 24th of April. What was that?
Yes, yes, that
What
is the
was
order
that?
at 58. Page 58 passed,
Oh,
the order passed by the authority under section, not 58, my lord, sorry, give me
No.
1 minute. Page 56.
Acha.
That is the page 56. This
Oh.
is the being passed by, pursuant to and in compliance of the earlier order dated 9th April
Oh, no, no. The
2024.
learned single judge directed stay of operation of the notice under section 10 till that temporary license was decided.
Yes, yes, that is page 56. Lordship, kindly come to page 56.
Yes, we have seen that. Who is appearing for the respondent? Have you given notice? Yes. Mr.
Yes,
Mukherjee,
yes,
how
yes.
could it be done?
Yes. Compared to
Section
the
10
earlier
notice
order.
is independent. Section 10 notice is that you are illegally encroaching. Proceedings are undertaken against you.
Grateful to Lordship.
We asked who is for the respondent.
We have served that.
See, if you have an addiction of getting abused on behalf of the respondent, we cannot help. No, we'll stay this order and serve copies, Mr. Department will stay operation of the impugned order.
Grateful Lordship, grateful to your Lordship.
By the impugned order, comma, there is what is the defect? You have to clear the defect during the course of the day. We'll also give the clarity.
Lordship,
Mr. Mukherjee,
I'm telling my junior to
Yes,
Lordship.
yes. প্রথম লাইন কেটে করো the learned advocate on record for the appellant shall remove the defect as pointed out by the office report. Full stop. Next para. By the impugned order, comma, the learned single judge has directed the appellant has directed the authorities concerned consider an application by the writ petitioner stroke private respondent under purportedly under section 8 within bracket 1 of the West Bengal Highways Act for permission to run a business on property which is apparently an encroached property by the which is apparently a property encroached illegally by the writ
And
petitioner.
belongs to higher authority.
Push up next para. Prima facie, it is apparent that initially proceedings were initiated and pursuant to a direction of a learned single judge of this court, comma, the highway authorities had initiated proceedings under section 10 within bracket 1 of the West Bengal Highways Act for removal of the encroachment by the writ petitioner. Full stop. During pendency of the same and apparently to frustrate the said proceeding, comma, the writ petitioner made an application under section 8 within bracket 1, comma, which was not maintainable prima facie in view of the ongoing proceedings for removal of encroachment. Full stop. That apart, comma, the learned single judge granted stay of operation of the notice under section 10 of the West Bengal Highways Act, consideration of such application by the writ petitioner, full stop, ex facie, comma, such application was not maintainable during pendency of the proceedings for eviction, full stop. Secondly, comma, the proceedings under section 10 of the Highways Act could not have been stayed merely by virtue of an application under section 8 of the said act. So thirdly, comma, it is doubtful as to whether section 8 is attracted in the present case at all, comma, since it contemplates temporary permission, whereas the petitioner sought permanent license to carry on business on the property in question. Full stop. The appeal shall be heard on the above questions. Full stop. In view of a strong prima facie case for hearing having been made out, comma, there shall be stay of operation of the impugned order, disposal of the appeal. Full stop. The
authorities would be at liberty to act.
Mr. Devarman, without hearing them, I will not add anything further. That will be adding insult to injury. The appellant shall
I'm
serve
careful.
copies of the
Careful.
memorandum of appeal and the pending applications on the respondents
If
and
not
file an
at all.
affidavit, if not done previously, and shall file an affidavit of service to that effect on the next date of hearing, full stop, liberty to the parties to mention for hearing when the matter is ready for such hearing.
Careful, your lordship.
Yes, আরেকটা matter হবে।
Unmute করে দাও। Unmute করে দাও। আমাকে বের করে দাও।
I for the petition led by Milord.
Led by?
Lord, am I audible, my lord?
Yes, yes, Mr. Hussain, yes. What is the matter?
Lord, my lord, the appellant herein passed a higher secondary examination from
Yes.
Bihar Intermediate School Council from in the year 2000. Thereafter acquired BSc degree in the year 2004, participated in TET 2014, qualified the same. Thereafter participated in the counseling process for appointment to the post of assistant teacher under DPC Shiliguri, Hindi medium, my lord. But her candidature was withheld, although she was an empaneled candidate, my lord. If your lordship kindly comes to page 30 of the stay application, my lord. It's the higher secondary mark sheet, my lord.
No, but the Bihar board has written that it is forged document.
My lord, with regard to that, my lord, if your lordship kindly comes to page 50, that's the report.
Page 50?
Page 50, my lord, there's a report filed by the West Bengal Board of
50.
Primary Education. The last two paragraphs, my lord.
Yes.
If may I read, my lord. After much such virtual discussions scheduled on 17/8/2023, the Bihar School Examination Board by memo dated 18/8/2023 addressed to the Secretary School Education Department Board in no certain time, despite that the memo dated 2/7/18 being annexed R1 to a supplementary affidavit filed by the petitioner is a fake and forged one. The aforesaid memo bearing dated 18/8/2023 is appended to this report. In view of such petition, written inputs from the examining body being the Bihar School Examination Board, thereby turning the document of the petitioner relied upon before this court in her supplementary affidavit as fake and forged. The entire matter is now laid before the Honorable Court for suitable and appropriate directions. My lord, the Bihar School Examination Board in no way has denied the testimonials of the appellant, my lord. They have simply said that the memo dated 2/7/2018, which the appellant had got from some of our friends, that has been denied, that has been declared as fake and forged. My lord, further, if your lordship kindly comes to page 63 of the stay application, my lord, a memo has been annexed in the same report, my lord, which substantiates the claim of the appellant, my lord.
Please show us the memo which has been held to be fake.
My lord, the memo is at page 43, my lord.
Let us see that first, whether it has any effect on you.
Well, the appellant had got hold of the document from some of our friends, my lord.
Right.
It's not something that we have produced. We have.
So, but you rely on this. You relied on this memo only.
Yes, my lord, we have relied on that, my lord.
If this is fake and forged, then what remains?
My lord, another memo has been annexed, my lord. Kindly come to page 63 of the stay application, my lord.
63.
It has been annexed in the memo, in the report, my lord. It has been sent by the Bihar School Examination Board to the Secretary of the West Bengal Board of Primary Education. At serial number 3, my lord, the name of the
Yes.
appellant is appeared. Shipra Mondol, my lord.
Yes.
If your lordship compares the roll number, the marks obtained of the appellant and the credentials given in the memo, my lord, it exactly matches, my lord.
And where is that communication dated of July 2018, which says it is fake?
My lord, it is at page
2nd July?
Page 50, my lord.
Page 50 is that?
2nd July.
Oh,
That
page
memo is at page 43, my lord. Fake memo is at page 43, my lord.
No, not the fake memo. The communication by them, the subsequent communication by the Bihar board. Where is that?
That is at
2nd July, because the West Bengal board has relied on that 2nd July communication, which says
Yes,
it is
my lord.
fake. No, the subsequent communication says that it is forged. The court relied on that. What is the harm in that? The
Now,
subsequent- No,
the
no.
memo which has, no, kindly hear me out, not kindly hear me out. The Bihar School Examination Board has specifically said that the memo dated 2/7/2018 that is fake and forged.
Yes.
But if you also kindly also page 63 of the stay application, memo dated
63, yes.
3/4/2018, page memo dated 3/4/2018, that substantiates the claim of the appellant, the roll number, the marks obtained by the appellant produced at the time of counseling in the writ petition exactly matches with the records, This has not been considered by the learned single judge.
No, we don't understand. Please repeat. This 3rd of April 2018.
3rd of April 2018 already. Yes.
This is another. This is what? Verification of mark sheet.
Yes, my lord. This report was sought for by the West Bengal Board of Primary Education in the year 2017. Now, this, if your lordship kindly peruses this record, my lord, the marks obtained by the candidate.
Was
the
this placed
enrollment
before the
number-
learned single judge? Was this placed
Yes, my lord.
before the
Yes, my
learned
lord.
single judge?
Yes, my lord. Dear, if your lordship comes to impugned order, my lord.
Yes.
Para 4. Counsel for the petitioner, however, relies upon an earlier communication dated 3/4/2018, purportedly issued by the Bihar School Examination Board, where the particulars of the petitioner have been stated to be correct. However, this court notes that the communication dated 27 July 2018 has a substantial similarity with the particulars in the communication dated 3rd of April 2018. The substance of communication of the Bihar School Examination Board is therefore that the particulars of the secondary examination produced by the petitioner are completely forged and fictitious. Then the learned single has completely failed to consider this memo, which has been annexed in the report filed by the West Bengal Board.
Very well. We'll admit the appeal. Serve copies on the respondent. Come back. We'll record the ground on which we are admitting.
Is a stay granted?
There is no scope of any stay. Your writ petition was dismissed. Stay cannot revive it. You had filed a writ petition. We cannot give you the final. That will be giving you the final relief. Learned counsel for the appellant argues that whereas the learned single judge placed reliance on a communication dated July 2, 2018, which was issued to the West Bengal Board to indicate that a particular memo showing the number, showing the marks of the petitioner was fake and forged, the learned single judge failed to take into consideration that irrespective of the veracity of such fake, allegedly fake memo, the document dated April 3, 2018, issued by the Bihar School Examination Board within bracket senior secondary bracket close, shows that the petitioner apostrophe s disclosed marks were correct. Next para, learned counsel contends that the learned trial judge failed to take into consideration as to whether, irrespective and independent of the allegedly forged document, the petitioner's disclosed marks and division stands vindicated by the earlier communication dated April 3, 2018. The appeal will be heard on such ground. Accordingly, the appeal will be heard on such ground along with the connected application. Learned, the appellant shall serve copies of the memorandum of appeal and the application on the respondent. The lower court records be called for. The appellant shall prepare informal paper books within 4 weeks from date and serve copies of the same to the respondents, directly and not through their learned advocates, who have liberty to mention for enlistment for hearing of the appeal after the records arrive and are found to be complete. Thank you. Thank you. Now the bail matters will be taken up.
One mentioning that if another day can be taken for this.
Well, at least one half. Then he has to pay for the mandamus.
No. Next circuit. Go before the next circuit.
Some of the matters are extremely urgent. Otherwise,
We appreciate, but we have to. No, we don't have time. We don't have sufficient time for that. The criminal appeals are also important. No, people are behind the bars, Mr. Bosch, no. No, for that day, make this employer on the first day before the next circuit, so that this schedule can be arranged. We have arranged this of our own. Anyway, let us call the bill. What is this?
I appear for the petition.
Yes.
For the state, Madam.
Right. Yes, Mr. Bhattacharya, what is it?
Allegation is recovery of 35 grams of brown sugar, my lord.
What is the mitigating circumstance?
My lord,
250, my lord. Intermediate one.
my lord.
250 is the.
Two. Yes, my lord. Co-accused was granted bail by.
Why do you move criminal matters, Mr. Bhattacharya? You're as proficient as me in criminal matters, which is very evident. Learned counsel for the petitioner points out that the quantity recovered from the petitioner was intermediate, and as such, the rigor of section 37 of the NDPS Act is not applicable. Full stop. Heard learned counsel for the state who opposes the prayer for bail. Full stop. However, keeping in view the mitigating circumstance as indicated above, we are inclined to grant bail to the petitioner. Accordingly, CRM NDPS 363 of 2024 is allowed, granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with 2 sureties of like amount each, one of whom should be local, to the satisfaction of the special court within bracket NDPS Act, additional session judge at Alipurduar. Charge has been filed. আচ্ছা তাহলে কন্ডিশন গুলো বলে দিচ্ছি ফার্দার the petitioner shall not make directly or indirectly an inducement, threat or promise, এটা তো ইউজুয়াল। তারপরে হচ্ছে moreover the petitioner shall meet the investigating officer once a fortnight during the entire period of investigation and shall cooperate in every manner with the investigation, and thereafter shall attend each and every date of trial and throughout the period of investigation as well as the trial, shall not leave the territorial jurisdiction of the trial court without the leave of the jurisdictional court. Yes. Not, you are appearing? Not today.
Lordship, I am for the petitioner, Lordship. 40 bottle of cough syrup, co-accused granted bail by this honorable court, Lordship.
Similar footing?
No, Lordship, recovery from my position, but a seizure witness, one independent witness and other is police personnel, and Lordship, lab.
One independent witness is sufficient.
One witness, Lordship.
The only witness was police witness. So there was one independent.
Yes, Lordship, lab report was received after 46 days. Labs.
Not so much, not so much.
Lordship, kindly see the charge sheet, Lordship, charge sheet submitted, Lordship.
Yes.
I did not annex the copy of the charge sheet, I have the copy.
The charge sheet, charge sheet. Yes. No, it is not there.
5, Lordship. Column number 5, Lordship, that is the, I was written that the sample was taken on 5th January 2024 prior to incident of the case. And it was sent it to the
15 January. 15 January.
15 January 2024.
What was that incident?
It's registered on Lordship, 28th March 2024, Lordship. And send it
What?
to the. Yes, Lordship.
20th March case was registered.
Yes, Lordship.
And it drew sample on 15th of January.
Lordship, and send it to the
Sample sent 2nd April 24. Charge sheet submitted, Lordship.
Paragraph 5 of the charge. This is the charge sheet, paragraph 5.
Yes.
See paragraph 5, sorry. Paragraph 5 of the charge sheet. Sorry. Send the sample on 15th of January.
2nd April 24. Sample sent.
What is this then?
Kindly see the paragraph 5. Fifteen one,
Typographical
2015.
mistake, yeah,
Lordship,
absolutely.
15. And Lordship,
No, nobody could be so naive that he will write that it was a culture. This is palpably a technical error.
Lordship. And Lordship, receive sample report received after 46 days left, Lordship.
We'll consider, but no. And one of the Caesar witnesses was independent, another
And
witness
the police, Lordship, co-accused granted bail, Lordship.
not recovered from him.
Lordship, co-accused.
Learned counsel for the petitioner argues that a co-accused person has been enlarged on bail. Subsequently, comma, the charge sheet, comma, in paragraph 5, comma, indicates that the sample was sent on January 15, 2024, whereas the alleged offense took place much thereafter in the month of March 2024. Thirdly, comma, the lab report came after 46 days, which delay vitiates Rule 14 of the NDPS Rules 2022. Learned counsel for the state opposes the prayer for bail. Upon hearing learned counsel for the parties, comma, we are of the opinion that sufficient cause has not been made out by the petitioner to displace the presumption under section, displace the rigors of section 37 of the NDPS Act. Insofar as the co-accused person is concerned, comma, no recovery was made from the said co-accused, whereas recovery was made from the present petitioner, comma, therefore the footing of the two are different. Next para. Secondly, comma, the date of sending of sample mentioned in clause 5 of the charge sheet does not tally with the rest of the documents, which go on to show that the sample was actually sent after recovery on the date of the offense. As such, comma, for such patently technical error, comma, the recovery and the seizure and arrest cannot be vitiated. Thirdly, comma, the delay of 46 days, comma, although exceeding the outer limit as per Rule 14 of the 2022 rules, comma, is not so large as to vitiate the entire process, comma, particularly taking into consideration the gross dearth, DEART, dearth of designated laboratories to undertake the required chemical tests. Next para. Accordingly, we are not inclined to grant bail. CRM NDPS 365 of 2024 is dismissed. Sorry. Yes. Next. এটা ওনাকে দিয়ে দাও petition. Yes.
I'm on behalf of the
Yes.
Lordship, petitioner name transferred on the basis of the co-accused person's lordship.
Use the microphone. Petition has been. Use the mic just.
My name transferred on the basis of the co-accused person's lordship. Nothing has recovered from me, lordship, and the another co-accused persons, namely Aminur Islam, granted anticipatable by this honorable High Court, lordship.
That is the person who gave your name. Anyway, these two grounds are sufficient. We record your opposition. Learned counsel for the petitioner argues that a co-accused person standing on similar footing as the petitioner has already been enlarged on bail. That apart, comma, no recovery was made from the petitioner, but the petitioner was arrested merely on the statement of a co-accused person, which is not sufficiently valid in the eye of law. Next para. The prayer for bail is opposed by the state. However, comma, in view of the mitigating circumstances as indicated by learned counsel for the petitioner, comma, we are of the considered view that the bar of section 37 of the NDPS Act is not applicable to the petitioner. Accordingly, CRM NDPS 366 of 2024 is allowed, usual to the satisfaction of the Special Court NDPS Alipurduar.
I'm appealing with
Yes, sir. What is your case?
648 days in custody. Lordship. Two petitioner, 110 kg of gaja was recovered from the vehicle. The petitioners are the driver and the khala.
What is the stage of the trial?
Stage of trial has not yet started. The charge has been framed, but on last two occasions, the de facto complainant failed to appear. So trial has not yet been started.
What do you say?
Lordships. Lordship, first of all, I will invite your lordships.
Yes.
Three coordinate bench already rejected regarding several grounds, your lordships. Actually, they are not interested in the trial. They are interested for bail, your lordships. Knows better than
Custody.
state, your lordships. Lordship, first of all,
No, they have paid for time before the trial court.
yes, your lordships. If a status report is called for, your lordship, it will be found. So far,
I have managed the entire order.
lordships,
Now let him finish.
when he.
Yes, right. Agree.
First, you complete your submission.
No, no,
We don't agree on that. We agree that you should complete first. Yes.
Lordship, first of all, lordships, huge quantity of ganja, 110 kgs, and they are taking various plea. Even they have sometimes they have prefer a bail application after rejection of your lordships. Lordships, last order, they have taken one plea that when the charge sheet has been filed, the vehicle's number is different. Regarding that point also considered.
Only 640 days is our consideration. When was it last rejected?
Lordships last dated
on April.
April, your lordships. And your lordship also considered and rejected, your lordships.
That was a very cryptic order, our order. Absolutely cryptic order.
After lordships,
Nothing was decided there, yes.
after charge sheet, your lordships, on the April.
No, Justice Chakraborty's division bench is an elaborate order, we find that.
Even they
But
have
this
taken
period of custody was not never considered.
discrepancy as alleged in on behalf of the petitioner would be analyzed.
Supreme Court has held time and again 300 something days, 200 something days.
Here, lordships, huge quantity, your lordships.
Quantity, but what will you do? Charges have been framed.
Lordship, give a direction so that we can.
How many witnesses?
Lordships, so this is your lordships.
640 days is sufficient.
Lordships, within 8 months, we will conclude. Lordships,
Why should he be behind the bar for 8 months?
Lordships, there is a.
Let him enjoy free air before he is convicted.
Lordships.
Not he, they.
Everything is formalities, everything's.
Always have the right to seek for cancellation if they jump bail or flout any of the conditions.
Your lordships, if you are only called for the report from the trial court, your lordship, your honor will be, your lordship will be found that after rejection, they are not interested about the trial proceedings, and they are taking a various time. And others point is, your lordships, our NDPS case is overburdened. Your lordship knows better than us, your lordship. So my humble submission, let directions and time frame.
After knowing that it is overburdened, courts are overburdened, we will give a direction. It is self-contradictory. What are you saying? We know that it is overburdened. That is the reason we grant these bails. We are being very candid. If you are confident that we could direct the courts and that would be complied with, what is the question of grant of bail in NDPS? We don't derive fun out of it. We speak of personal liberty and all these things. Definitely Article 21 is there. But Article 21 is modulated for persons who are accused in cases. But we know that these trials will never be over within the timelines. That is the reason we grant bail and put in conditions. No other reason for grant. We don't derive any fun from that. 640 days is sufficient. Learned counsel for the petitioner contends that the petitioner is in custody for 648 days and that on the last 2 occasions, the de facto complainant did not turn up, for which the trial could not be proceeded with. So next para, learned counsel for the state vehemently opposes the prayer for bail and argues that at least 3 coordinate benches have rejected similar prayers of the petitioner, lastly on April 3, 2024, upon considering all facets of the matter. Next para, it is argued that the petitioners are not interested in completion of the trial, but in seeking bail repeatedly. Next para, we find from the records that the petitioner's previous applications for bail had undoubtedly been rejected. Next para, however, we cannot lose sight of the fact that as yet, only the charges have been framed and no witness has yet been examined, whereas there are as many as, how many witnesses you said?
15.
As many as 15 charge sheet witnesses. Since long incarceration itself is a sufficient ground for diluting the rigors of Section 37 of the NDPS Act, as had been held by the Supreme Court time and again, we are inclined to grant bail to the petitioner. comma, of course, comma, on conditions. Full stop. Accordingly, CRM NDPS 367 of 2024 is allowed with usual conditions. Satisfaction of
Special court NDPS at Jalpaiguri.
Special Court NDPS Act, Jalpaiguri.
Lordship, local surety may be imposed, your lordship, local surety.
Yes, one of whom has to be.
110 kgs of.
No, no. Our default order is one of whom must be local. We do not generally grant with landed property because these are not the kingpins. As the kingpins, bring them before the court. Let us and see whether we grant bail or not. Show us that these are the kingpins. Yes. Not today. You're appearing? Yes.
So kindly see at page 17 of my application, which is FIR. There are two sets of accused person. So one set of accused person is namely as Abdul Kalam, Abul Kalam Azad, Moidul Islam, and Moidul Islam.
You are Saddam. You are Saddam.
Yes, Saddam. So this set of accused persons, it has been stated that the recovery was made from item number 2 to 7. Item number 2 to 7.
Right.
Next, item 16 and 17, it has been purportedly seized from the petitioners, that is Saddam and Hafizul.
Right.
It has been stated in the next page, page 18. It has been in bold. It has been stated that it has the contraband was seized from Hafizul and Saddam. Next, at page 19 of the FIR, the real-time seizure and the actual FIR the content, the allegation is this. I am reading out the relevant portion at first paragraph. We have seen one truck displaying registration number so and so, and one Royal Enfield bullet displaying number so and so were standing beside the road, and aforesaid 5 arrestees, that means the petitioner and 3 person, 5 accused persons arrestee, another 1 accused person were exchanging total 3 bags, and 3 of them of the said arrestee Abul Kalam Azad, Moidul Islam, boarded in the truck with a bag as mentioned in seized article, serial number 10, and it's containing 1 about to board in the truck, and rest 2, that is the petitioners, rest 2 rided in the bullet with 2 bags as mentioned in seizure list item number 21 and 24. Let's kindly see item number 21 and 24 contains only the money. There is no recovery indeed from the position of the petitioner. Despite the same, it has been made out in the FIR itself that the contraband has also been recovered. But this is how the entire.
No, this is in addition. They say even at page 19, they say that bags were being exchanged between you. 2 bags were exchanged by you also.
No, that 1 person has.
And another one,
one person had paid out.
Above 5 said 5 arrestee, and another 1 person were exchanging total 3 bags, and 3 of them then whatever boarded truck, and you 2 went to the truck. So you are exchanging the bags.
Bag means, this bag is containing the money. That is article. Yes, article 21. 21. The one.
You were there at the site along with them. You were exchanging bags.
21 and 24 bags.
This money was for what purpose? For charitable donations?
No, certainly not.
It's the connection is very.
Certainly.
No,
no contraband from my position.
Maybe. Your involvement is very clear.
It is palpable on the face of the record. It is palpable on the face of.
No. So much money was being exchanged.
I'm leaving it, Lordship, because there is admittedly there is no contraband being recovered from myself.
Learned Counsel for the petitioner submits that no contraband article was recovered from the petitioners themselves. Push up as evident from the FIR, as per Learned Counsel for the petitioners, the only recovery from the petitioners was 1 black color side bag containing money, and 1 yellow and saffron color striped nylon shopping bag also containing money. Push up next para. Hence, it is contended that the involvement of the petitioners in dealing with the contraband articles is doubtful. Push up. Learned Counsel for the state opposes the prayer for bail and also relies on the FIR. Push up. We find from the FIR that the involvement of the petitioners as per the allegations was direct, since huge amounts was of cash were being carried in the bags recovered from the petitioners at the very site where the contraband articles above commercial quantity were being exchanged by the five arrestees, comma, including the petitioners. Full stop. Thus, comma, even if there was no immediate recovery from the person of the petitioners regarding the contraband articles, comma, the role of the petitioners in the offense is palpable as per the FIR. Full stop. Hence, comma, we do not find any reason to uh, bypass the bar under section 37 NDPS Act in case of the petitioners. At this stage, full stop. Petitioners, full stop. Accordingly, we are not inclined to grant bail at this stage. CRM NDPS 368 of 2024 is thus dismissed.
Grateful. Next.
Lordship, I am for the petitioner.
Yes.
Lordship, the petitioner is in custody for 99 days, Lordship.
Except that.
Lordship, the seizure was done on 19th March 2023. And my Lordship, in this case, 22 days delay, unexplained.
After lapse of 22 days, the matter was sent for RFS. And the report was received after lapse of 3 months and 8 days. There is a clear case of violation of Rule 14 of NDPS.
Yes, Mr. Lakshman, what do you say? Still focusing.
Yes, madam, I'm still focusing on the 21 days, madam, the delay.
No, from the same.
No, sending of the from receiving, sending of the report took 3 months. Eight.
What are 3 months?
19,320.
Learned counsel for the petitioner contends that the petitioner is in custody for 499 days. There was a lapse of 3 months and 8 days between the chemical laboratory receiving the report and issuing, receiving the sample and issuing the report, which is in violation of Rule 14 of the NDPS Rules 2022. Next parallel, counsel for the state seriously opposes the prayer for bail. However, comma, in view of the period of custody and the gross contravention of Rule 14 of the 2022 rules, comma, we are inclined to dilute the regards of section 37 NDPS Act. Accordingly, CRM NDPS 369 of 2024 is allowed, usual to the satisfaction of Special Court NDPS Siliguri.
I think 80. This matter, morning I mentioned this matter.
79.
Direct to be appeared tomorrow, but I.
Oh,
79.
এটা 79 তো?
না, ওটা হয়নি তো।
79 is mentioned for tomorrow. 79, the other side is there, then we can take 79 and 80 are connected.
Was with 75. 75 has been moved. Now 79 was not moved that correctly.
79 দিন এর কোন অর্ডার তো পাস করেনি 79 টা 75 what happened? We granted.
Wife of the petitioner is pregnant, expected delivery in the month of August. In this, for this reason, I mentioned this matter in the morning, my lord. But although my renewal of my prayer for bail was turned down on 25th of April 2024, my lord.
She was pregnant then also. Anyway.
Well, only on otherwise, apart from the humanitarian ground, there are no other illinois.
My lord, charge sheet was submitted in the month of my lord, 20.
So grant to limited bail till delivery of the child.
Another thing, if you also submit once in the month of February last, charge sheet submitted, till to the charge not frame, there are other co-accused absconding. There is remote possibility to commencement of the trial.
How many co-accused are absconding?
There are 4 co-accused.
4 are absconding.
One granted anticipated bail.
You think they will grant bail, Mr. Yeah, thank you for doing that. The court thanks you. Learned counsel for the petitioner contends that the petitioner's wife has conceived and the due date of delivery of the child is in the month of August 2024. Push up that apart, comma, in view of several co-accused persons absconding till date, comma, there is remote chance of early disposal of the trial. Pushed up. being learned counsel for the state opposes the prayer for bail, full stop, however, comma, on the grounds made out by the petitioner as indicated above, comma, we are inclined to grant bail. Accordingly, CRM NDPS 370 of 2024 is allowed, usual, uh, to the satisfaction of Special Court NDPS Alipurduar. Alipurduar.
Deep throat.
Thank you. 80.
PT, I'm appearing on behalf.
This is the last matter. Nobody will shout after this. Yes.
81 just, yeah, my request.
There has to be a cutoff. What are you doing? Everybody will up to 81. Yes. Yes, Ms. Asha. Quick.
The name of the petitioner transferred from the statement of the co-accused from whose possession the contravent has been recovered, your lordship. There is no bar of section 37 of the NDPS Act, your lordship.
Name of this petitioner transfers from the 161.
Learned counsel for the petitioner contends that the petitioner was arrested merely on the statement of a co-accused person and no recovery was made for the petitioner. Full stop. Learned counsel for the state opposes the prayer for bail. Full stop. However, comma, in view of the mitigating circumstances as narrated above, comma, we are of the opinion that the rigor of section 37 NDPS Act is not applicable. Accordingly, CRM NDPS 371 of 2024 is allowed. Usual satisfaction of which court?
NDPS Special Court Alipurduar, your lordship.
Yes. Right. Next. 81.
81.
Last matter, yes.
My lord, I am for the petition. I will not take too much time. This is a gross violation of Rule 14. Since the representative sample received by the laboratory on 3rd day of November 2023 and report submitted on 6th day of February 2024, that is after 3 months. Meanwhile, the accused is in custody for a period more than 293 days, and de facto complaint on 5 occasions failed to appear before the learned court, and that's why trial has not been proceeded.
What do you say?
CFSL report received on received by the CFSL on 3rd of November 23. And CFSL report was completed on 6th of February, only minutes.
3 months.
2.5 months.
3 months.
Not 3 months.
No, more than 3 months.
More than
Oh, 3rd November to 6th February.
6. More than 3 months.
more than.
Outer limit is 30.
My lord, last occasion it was 5 months. Now my lord has reduced to 3.
No, not that. 293 days custody.
290.
There are 3 mitigating circumstances argued by the petitioner. So first, comma, the provisions of Rule 14 of the NDPS Act 20 of the NDPS Rules 2022 have been flouted since it took the chemical laboratory more than 3 months to furnish the report from the date of recovery of the sample. Secondly, comma, the petitioner is in custody for 293 days. Thirdly, comma, the trial could not be commenced due to the absence of the de facto complainant on 5 consecutive dates. Next para. In view of the above conduct of the de facto complainant, comma, we are not confident as to the early conclusion of the trial. Moreover, comma, the petitioner is justified in arguing that there was gross contravention of Rule 14 of the 2022 rules, comma, thereby mitigating the rigor of Section 37 NDPS Act. Accordingly, CRM NDPS 373 of 2024 is allowed, usual to the satisfaction of Judge Special Court NDPS Alipurduar.
My lord, one indulgence, my lord. My lord, I'm not asking you to take up any matter, my lord. Pray for upgradation, my lord. Just 3 matters, my lord. Any day, any of these 3.
Why?
Lordship, this was filed.
No, we have refused several other
Lordship,
persons.
filed on the previous survey, lordship. He's in custody for almost 5 years, lordship.
No.
Lordship, it does not pertain to NDPS Act, lordship. Kindly, lordship. Kindly, lordship. Any of these.
All of these 3 5 years.
No, lordship. One is 5 years, and the other 2 are around about 2 years, lordship.
Give the 5 year only.
Lordship, I've given the number.
Only the 5 year. এইটা শুধু ওই 2 PM যেগুলো কাল ফিক্স করেছি তার সঙ্গে।
My lord, one indulgence, my lord, this is also an upgradation matter, my lord, because the mother of the my lord, nothing has been recovered from the petition. Mother of the petitioner is in hospital, my lord.
You have refused in the morning.
My lord, in the morning I moved, he is in custody, the petitioner is in custody for 6 years, my lord, for upgradation in the list.
My lord, kindly.
6 years.
Yes, my lord.
NDPS.
Yes, my lord.
আচ্ছা দিয়ে দে। Yes, give it.
NDPS, my lord, not NDPS.
Hand over. এটাও দিয়ে দেবো। 5 years নিয়েছি 6 years. 5 or 6?
3 years.
No, not qualified.
2021, my lord.
My lord, I'm in custody of because 1 year, my lord. Kindly.
For 2021,
Any day, my
Lord 6.
Mentioning slip দিয়ে দিচ্ছি।
What was the nature of the interim order? Just tell me.
Interim order, Lordship, the impugned order was stayed. The impugned order was directed to vacate the premises.
Acha, that was
directed the
clear.
petitioner to vacate.
Have you filed any separate application for extension?
Yes, Lordship.
Can two or
Can two.
what do you say?
So at page 12, the first order of stay. Page 12 of my application.
Give me half a minute. I'll come to you. Yes, what do you say?
1 minute. Lordship. Subsequently, they sought for time to file their affidavit, and a long time was provided.
Affidavit to the main writ petition.
Main writ petition. In the second round of extension.
They did not file it?
No. As on today, no.
Let us hear them. Yes, 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 sir. What do you say? Right. What is the ground for vacating? Mm-hmm.
Building which is owned by the respondent of 5, and respondent of 5 has initiated the proceeding under the Senior Citizen Act of 2007. So order has been passed by the.
Let us come to that impugned order once. Come to that page of the writ petition.
Page 43.
42, 43.
42, 43. 43. The original order, then the
original order is
impugned order is the last page, 56. Non-speaking order. Complete.
56. HS here is better. So 56 is that is made absolute.
Yes.
Acha, 43 let us see then was. You are the maternal uncle. Grandfather.
Grandfather.
Paternal grandfather. Father's father.
Yes.
So you are looking after a child. And they have filed this, you have filed this application. What are the facts? Give me an answer. If you want, we both of you want, we can take up the writ petition itself and I'll dispose it. Can I do that?
And my elder daughter-in-law is the daughter of the petitioner number 1. My daughter-in-law.
Your daughter-in-law is the
daughter of petitioner number 1.
Yes.
That's not it.
Yes, they are the maternal side, you are the paternal side. You are the paternal grandfather and they are the maternal grandparents. Achha, very well, yes. So you are Beai Beyan, basically.
Exactly.
Very well, yes. What then? What next?
The daughter-in-law is succumbed to death prematurely. And despite of several treatment, she could not survive. Now the child, who is practically in the custody of the
Paternal grandfather.
Grandfather and the father, the petitioner, they on the plea of looking after the child, they have entered into the premises and they are not now leaving the premises. This is the smooth.
Your premises.
This is the moot question. And in spite of several requests, when they
Is the act applicable? You have to file a regular suit. They are not your dependents. Or neither are you their dependents. You are you the parent or senior citizen itself does not do. Yeah, they have to be your dependents. Let us see the act once. Do you have a copy of the act? Under which provision you have sought for this eviction? Show me the provision.
Their application is at page.
No, I'll look into the provision. They have quoted any provision in their eviction or
No.
what, under which provision of this act have you applied?
Section 5 is application, filing an application, section 5. And the statutory.
No, 4 is the parent provision. They do not come within the purview of the act. Your application should have been rejected outright. Please come to section 4. Section 4 contemplates an application in case of a parent or grandparent against one or more of his children not being a minor, which is not the case. A childless senior citizen. You are not a childless senior citizen. If you are now you are childless because of the demise, but you are not a childless senior citizen. And in case of such a citizen, against such of his relative referred to in 2G. 2G contemplates relative means any legal heir of the childless, your legal heir who is not a minor and is in possession of the property. Sir, file a regular eviction suit. This is a gross abuse and we should impose costs against you. Absolutely. For filing this application before the SDO. This is a gross abuse of the process of this act. Yes. On consent of parties, the writ petition itself is taken up for hearing along with the applications. Full stop. The facts of the case in brief are as follows, colon, niche, paragraph. The present petitioner is the paternal grandfather of a minor child whose mother met her untimely demise. Full stop, next para. The respondents are the, no, sorry, you are the maternal side. Sorry. Maternal grandfather. Mother. Sorry. Brief facts part থেকে কেটে দাও. The petitioners are the maternal grandmother and the grand aunt or the aunt and the aunt of a minor child, whereas the respondent is the paternal grandfather of the said child. Full stop, next para. The respondent, comma, being the paternal grandfather, comma, alleges that in the pretext, on the pretext of looking after the minor child, comma, the respondents have entered into the petitioners have entered into the property of the present respondent and are not leaving the same, comma, compelling the present respondent to initiate a proceeding under the Maintenance and Welfare of Parents and Senior Citizens Act, comma, 2007, which culminated in an order of eviction. Full stop, next para. The petitioners allege that the provisions of the said act are not applicable at all, and as such, comma, the impugned order ought to be set aside. Full stop, learned counsel places reliance on the appropriate provisions of the act, including sections 4 and 5 of the same, in support of his contentions. Full stop, next para. Learned counsel for the respondent argues that the respondent, being a senior citizen, comma, was entitled to invoke the provisions of the 2007 Act, and in view of the occupation of the property of the respondent by the writ petitioners being palpably illegal, comma, the subdivisional officer was completely justified in passing the impugned order of eviction. Full stop, next para. The upon hearing learned counsel for the parties and a bare perusal of the statute in question, comma, it is evident that the impugned order is palpably without jurisdiction. Full stop. Section 4 of the 2007 Act stipulates that a senior citizen, including parent, who is unable to maintain herself from his own earning or out of the property owned by him shall be entitled to make an application under Section 5, full stop, subclause small ii of subsection 1 of Section 4 is applicable, which contemplates the case of a childless senior citizen, comma, against such of his relative, comma, referred to in clause small g within bracket of Section 2 of the Act. Full stop. Section 2 within bracket small g defines relative as any legal heir of the childless senior citizen who is not a minor and is in possession of or would inherit his property after his death. Full stop. Next para. The respondent in the writ petition ticks case all the wrong boxes in the present case. Full stop. First, comma, the said respondent is not a senior citizen vis-a-vis the writ petitioners, comma, since the writ petitioners are not the relatives of the respondent as defined in Section 2 within bracket small g of the 2007 Act. Full stop. Secondly, comma, the respondent is not a senior citizen who has proved to be unable to maintain himself from his own earning or out of the property owned by him. Full stop. Thirdly, comma, the respondent is not a childless senior citizen. Full stop. That apart, comma, the entire contemplation of the Act is to provide protection to senior citizens and parents who are unable to maintain themselves. Full stop. Next para. The respondent apostrophe s appropriate remedy would be to file an eviction suit before a regular civil court, and the invocation of the 2007 Act is a gross abuse of the process of court. Full stop. Next para. The SDO, comma, for the above reasons, comma, acted palpably dehors jurisdiction in passing the order of eviction. Full stop. Accordingly, the order cannot be sustained, comma, being not tenable in the eye of law. Full stop. Thus, WPA 651 of 2024 is allowed on contest, comma, thereby setting aside the impugned orders respectively dated November 6, 2023 and January 16, 2024, passed in appeal petition number 10/2023 between the present parties. Oh, I'm sorry. Setting aside the order of the district magistrate, যেটা বললাম, SDO না. Appellate tribunal, yes. Oh, the SDO passed an order against you?
Now, both SDO passed the order.
Acha, very well.
And that has been affirmed by appellate court.
Thank you very much. Order dated, and the page 43 order is the SDO's order.
SDO order, yes.
আচ্ছা, তাহলে last sentence টা কেটে দাও. WPA is accordingly WPA. Accordingly, WPA 651 of 2024 is allowed, comma, thereby allowed on contest, comma, thereby setting aside the order dated January 16, 2024, passed by the appellate tribunal in appeal petition number 10 of 2023, as well as the order dated November 6, 2023, passed by the subdivisional officer Alipurduar in petition number 41 of 2023. Full stop. There will be no orders to cost.
Grateful.
No costs.
So instead of respondent, all
Can such and such are disposed of in the light of the above observations as well.
all respondents as a respondent number 5. Because there
যেখানে যেখানে রেসপন্ডেন্টস বলেছি রেসপন্ডেন্ট 5 করে
grateful.
আরেকটা লাইন অ্যাড করে দাও. It is made clear that nothing in this order shall prevent the respondent number 5 from initiating appropriate proceedings in a competent civil court for eviction, comma, if otherwise entitled in law. That has no bearing with this. That has, if I mention anything on that, it may affect it. And that has no bearing with this.
Grateful.
Thank you.